Good morning, honorable members, honorable deputy minister. I am told that the custom is that the former chairperson of the Standing Committee on Public Accounts needs to come and sit here and do an official handing over before we proceed.
It's the first time this has happened, so we are setting into motion precedents.
And members of the Road Accident Fund team, good morning as well. I'm just going to make sure that the committee secretary is here so that the proceedings are properly minuted. So they're just going to find it, and then we shall begin. So before we begin, I just want to make sure, because we were favored with a presentation document. So I just want to make sure that it's, the person who's going to take us through it is, or are you going to distribute hard copies? Or Honorable Deputy Minister, your colleague has said that I must give him about 2 minutes, and I can take that 2 minutes from your time. That's what he was saying to me.
Chair, we are completely in your hands. Person, if I may, my apologies, and I
Yes.
regret to start off on apologies. May we beg your indulgence momentarily to sort out what, well, seemingly needs to be sorted out.
No,
on
that's
this-
fine. You
on
need
this
about
project.
5 minutes to do so.
5
Would
minutes
that
should
be
suffice to-
sufficient?
That would be sufficient.
Okay, that's fine. No, 5 minutes it is. So that Honorable Bloss and Honorable Atkinson can grab a cup of coffee. Yes. Okay, thank you. Are you sorted?
Chairperson, again, apologies. We are sorted out and good to go.
Sorry, Honorable Deputy Minister said we are sorted. Or sorted, not sorting. Okay. No, thank you very much. Honorable members, Honorable Deputy Minister, members of the Road Accident Fund leadership team, I think we've got, honorable members, there is one meeting. Honorable Blosse, don't be chairing another meeting there. Thank you. Yeah, please, order. And members of the Auditor-General's team, I see them. The Special Investigating Unit, this is not an investigation though, as a matter of course, they tend to be here during these conversations. But thank you very much for being here and for making the time. I really appreciate it on behalf of the committee. So I'm going to provide some context, not just to this conversation, but how we're going to work together. And I'll share maybe what you're likely to see as how the committee approaches its work over the next, during the course of the 7th Parliament. So obviously the work of the committee is vast. We cannot chase down every institution and look at everything because they number in the hundreds. So what you're likely to see is that there are thematic areas that we're going to focus on that have an intersection of service delivery impact as well as impact on the economy. And hopefully we're talking about positive impact. The general attitude of the committee is that we are not here to get people, and so there is no need to be anxious when you come here. This is a new administration, it's a new parliament. We all start on a clean slate. What is really helpful to all our proceedings is to trust one another with information, especially when that information is provided in a manner that gives the committee members the proper context, that where there are challenges, we ventilate them, we get the context to those challenges, and then we hold one another accountable to the plan for dealing with those challenges. I think if we work that way, you will find that the visits to the committee, when we either visit an entity or you come here, the interactions are robust, but they're conducted in good spirit and with a necessary level of respect between us, because we all want the same thing. If we can have every state institution functioning as it should, I think that all of us will be better off, the South African people will be better off. That's what we all need to work towards. And I'm saying this knowing that the Deputy Minister knows this very well because you were sitting in this chair, but that's the general attitude. More specifically, however, there are certain clusters that are really important in terms of this intersection that I spoke about. I will not mention all of them, but I will give you a sense. Because the idea is that we have regular conversations, but not so regular that we micromanage you. We don't want to micromanage ministers and deputy ministers. We also do not want to micromanage state institutions. That's not what we should be doing. We must have a framework and a timetable of oversight that is easily understood. It introduces regularity in our relationship, that when people come to account before the committee, they know exactly what the committee wants to know. We give you enough time to prepare and we speak to one another candidly. So that is going to introduce the level of regularity and certainty that in an entity like the RAF, the management should have with the board. You know when the board meetings are, you know what's going to be on the agenda, you know what reports to prepare and that kind of thing. So I'm hoping that we can work with one another in that way. So on to the themes. So the energy, electricity space is really important in South Africa. I don't need to tell you, it's not just ESCOM. There is all manner of things. There's the Central Energy Fund, there's Petro SA, etc., etc. So the energy space and electricity is very important. The transport sector is extremely important, and under the Department of Transport is the Road Traffic Management Corporation, it's the Road Accident Fund, Transnet, PRASA. You know the group of entities. They're all really important. So that's really important. The higher education space is important. It's not just the Department of Higher Education and Training, it is the CETAs, it is the NSF, it is NSFAS, and so on. So I don't need to give you the whole laundry list. I just don't want you to feel targeted because we can't do everything. But what we're going to try and do is to have such regular interactions at reasonable intervals so that we keep one another appraised of the issues and the challenges and what is being done about them, such that Parliament always has a level of comfort that things are going in the right direction. That's the idea. So I'm saying this to indicate that this is our first interaction. When we ask you to come here, we are not after you. I've had the same conversation with Transnet, with PRASA, and so on. The committee members are used to this speech by now, right? So that's all I'm saying. We're going to see each other regularly, not often, regularly. And those intervals will make sense in terms of what makes sense for you and so on. What I also don't want to do is to have senior people from the Auditor-General and the SIU and so on always sitting in Parliament all the time instead of doing their work. So I am mindful of all of those issues that you have to deal with, as well as the work of the committee. What we do expect in return for that, like I said, it is for you to be candid with us as the committee, to furnish us with information, good or bad, and to show us the plan of what is being done to deal with those issues. There is an intentional tension between Parliament and state institutions, ministers and state institutions. It's not personal. The system is designed to work that way. We ask the questions. The questions are an additional layer of quality assurance for the South African people. So that's why I'm saying we're not out to get people. If we work out, and I'm a fair person, you might have heard me commenting on other institutions. I'm not here to say things are bad. Where there are challenges, I say there are challenges. Where things are getting better, I say things are getting better, at least when I speak in the media. And I will be consistent with everybody. But the candor is really important. What is likely to happen after this meeting, because this is a first engagement, what is likely to happen after this meeting, or more than likely to happen, is that we will be in a position to develop an accountability template that you will understand, the committee understands, and so on. It helps with the committee processing the work that it does. There will also be a cadence of engagements between ourselves and various institutions, such as the Auditor-General, the SIU when necessary, and that sort of thing, so that certain processes can. So in other words, next time we are likely to have a presentation from the Auditor-General first, and that's been the practice in the committee anyway. Presentation from the AG, and then the entity itself. Sometimes it may not be necessary to have the AG here because the nature of the things we're talking about is such that it's not necessary. The final thing I want to say, I am well aware that we are not the Portfolio Committee on Transport. And so even though sometimes we may traverse into certain policy areas and so on, we do not intend to be the Portfolio Committee on Transport to replicate that work. Where it is necessary for us to traverse issues that touch both committees, the chairperson of the Transport Portfolio Committee and myself will be in discussion, and we will have a joint hearing so that we can also save you time. You don't need to come here and stay here whole week appearing before different committees. So there'll be that attempt to also help you, save you time here in Parliament so that we all work well together. I'm also aware of the constraints of time that you have, Honorable Deputy Minister, the number of entities you have to deal with, places you have to go to, etc., etc. So what I'm trying to say with this long opening is that we are going to get to a point where we assist one another to fulfill our respective mandates. That is the attitude of the committee. And with that said, Honorable Deputy Minister, welcome to this sitting. As I said, this is a first engagement. I'm assuming that you are going to make some opening remarks, firstly, and secondly, if you can introduce, or somebody from the Road Accident Fund introduces the team at an appropriate time. I will leave that up to you as well as to when that happens. And then at question time, when the members are engaging on the presentation, then we can we can also introduce them at that point. So thank you very much. You have the floor.
Chairperson, Honorable Chairperson, honorable members, the Chairperson of the Board of the Road Accident Fund and the Deputy Chair, the DG of the department, the DDG for roads, the CEO and the executives of REF, the Auditor-General, SIU. Chairperson, let me start off by saying in my 10 years of serving on the Standing Committee on Public Accounts, of which I had the privilege of chairing for 5 years, I always prayed and hoped I would never be seated here. But as it were, here we are. Chair, I want to start off by congratulating you on your election as the chairperson. And I am pretty certain that the committee oversight and accountability in our democratic discourse is in the right and capable hands. And I want to wish you well and assure you of my highest cooperation, consideration, and at the very least, even if offline, an ear to share experiences. Honorable members, I wish you well in your responsibilities and assure you that this committee, if it does the right thing for the right reasons, for no other reason than it being the right thing, it is strategically positioned as an enabler for oversight and for entities to be able to perform their functions. And so, Chair, I really want to wish you well, and I will endeavor, Chair, if I'm required, never to bother you with excuses. If you call me here, I will at the very least be here, but I know the headache of the apologies and so on and so forth. So, Chairperson, thank you very much. Chair, we are here really at your invitation on matters of REF, and I want to indicate, Chair, before I do my remarks, that the Chairperson of the board is here. What I will request is that maybe we do introductions, because this is our first meeting together, and then I will just make one or two remarks, and then we'll then hand back to the chair again and the executives who will go through the presentation which you have actually been furnished with. Madam Chair.
Thank you very much, Deputy Minister. Honorable Chair of the committee and honorable members that are here in our presence, and let me also recognize our Honorable Minister Chrissy in absentia, our Honorable Deputy Minister. Let me introduce myself. I'm Zanele Lorraine Francois. I'm the chairperson of the board. With us, I have our deputy chairperson, Dr. Maboya. She's sitting on my left-hand side. We also have the chairperson of the audit committee, Mr. Nyama, from the board. And then within executives, we've got Mr. Letwalo. Everybody knows the CEO of the RAF. And then we also have the CFO, Bernice Potgieter, and the Chief Operations Executives, Mr. Lukwareni. We also have the Board Secretary, Mr. Pinani, and the Chief Governance Officer, Ms. Kumalo. And I think that covers our delegations for today. Thank you.
Thank you, Slad. Chair, we are also here with the DG of the department, Advocate Mlao, and the DDG for roads, Ubab. Chair, I want to say that in the course of your work, the Minister has finalized the delegations of responsibilities insofar as the entities and targeted programs of the department are concerned. And so if you see us, if you require us interchangeably, it will be on the basis of the fact that entities have been delegated. Within my purview is the Road Accident Fund, the Road Traffic Infringement Agency, the Cross-Border Road Transport Agency, SAMSA, the Ports Regulator, and the RTMC. And then with a particular focus within the grants of the department, it's the subsidies on the ITN, it is the provincial roads maintenance grant, and the issues around stakeholder relations, particularly with the taxi industry, is a shared responsibility between the minister and myself. However, I am mindful of the fact that above and beyond that, mine is to support the minister, and so in the work that she does with her entities, I am readily available to actually do that. So, Chairperson, it is both an honor and with a sense of responsibility that one appears before the committee today as we engage on the matters related to the Road Accident Fund. At the outset, I would like to express my sincere appreciation to the committee for affording us this opportunity to present and discuss the challenges currently facing the RAF and to outline the steps we are taking to address them. The RAF plays a critical role in supporting victims of road accidents, providing financial assistance and ensuring access to justice for affected families. However, we are well aware that the fund has been facing significant difficulties in fulfilling its mandate. These challenges, both operational and financial, have impacted service delivery and the sustainability of the fund. As a ministry, I also want to state that we do not support the ongoing dispute between the RAF and the Auditor-General regarding the accounting standards being applied insofar as liabilities are concerned. The position of the ministry is clear. We believe that such disputes should not distract us from the urgent need to resolve the broader issues affecting the fund. Furthermore, we do not support court action that has been instituted by the RAF on this matter, resulting in 3 adverse judgments, as we believe these differences can and should be resolved through dialogue and mutual understanding. In addition, the current discussions in Cabinet about the rising cost of living, particularly in relation to the fuel levy which funds the RAF, must emphasize the need, therefore, to diversify the fund's revenue streams. This is critical to ensuring the long-term viability and sustainability of the RAF, and relying solely on the fuel levy, given the economic pressures facing South Africans, is not a sustainable solution. Finally, it remains our position as the ministry that any changes to the RAF, whether in terms of its operational model or accounting standards in question, must be addressed through proper legislative reforms. These changes must be thoroughly considered, debated, and aligned with the broader objectives of the medium-term development plan of ensuring that the RAF can meet its obligations both now and into the future. So today we are here with the board and the executives to provide clarity on these issues and to openly discuss the root causes of the current problems, including the backlog of claims, financial constraints, and administrative inefficiencies. I also wish to highlight that the corrective actions we are implementing, as well as future strategies that we believe will help us strengthen RAF's capacity and performance, are necessary to be discussed as well. Chairperson, we in the ministry remain committed to ensuring that the RAF fulfills its mandate effectively and that it continues to serve as a pillar of support for the many South Africans who rely on it during times of crisis. I therefore look forward to a constructive and transparent dialogue, as I am certain that the board and the executives equally do the same. We are ably in your hands, and I thank you for your ongoing oversight and guidance on this matter and the correspondence we have received and the interactions that we will have today. With that said, Chair, I would like to hand over to the chairperson of the board, who will then guide her team in terms of presentations, and then we'll hand over to you. Chairperson, over to you, ma'am.
Thank you, TM. And once more, thank you, Chair of SCOPA. And let me observe all protocols since I've already greeted everyone. Chairperson, thank you for your opening remarks and also assuring us of the objective and transparent manner that we're going to have our future engagements within this parliamentary and key committee. We do appreciate the work that this committee does in supporting all the entities in our government. And before I hand over to the CEO to present I'd just like to confirm that we are here to present our 2023-2024 annual report of the fund. And also we'd like to assure you, as we always do when we are invited here, that we are here to account to the people of South Africa. And as a board, this is our second annual report. As we've been in office for a year and about 2 weeks from the time we were appointed. It has been a very difficult and challenging year, but we can certainly assure you, Chair and the committee, that we have hit the ground running to ensure that we don't only sustain this organization, but also ensure that we don't lose any gains that were actually made by our predecessors, but also to try and improve where there are setbacks. This report will indicate that we have added an extra area of audit, as it will be indicated in our presentation. And we are confident that this will give South Africans assurance that we continue to improve on our governance in various areas. We not only have the Auditor-General auditing in our space, but we also have the SIU in our midst, assisting us in fulfilling this very critical mandate. We continue to cooperate with the SIU chairperson. And together we have collected about 1.2 billion of duplicate payments, some of the challenges that we pick up on the system when the board was starting with its turnaround strategy. And we will continue making sure that this organization is stable. So at this stage, Chair, I'd like to hand over to the CEO, who will take us through the detailed presentation, and the rest of the team. I thank you.
Thank you very much, Chair. Over to you, Mr. Lutswalo.
Thank you very much, Chair. Let me recognize the presence of the Deputy Minister and all honorable committee members, the presence of the AG and SIU. Chair, I'm going to go through this presentation on the basis of the outline that we're given. I'm going to try to be quick, Chair, on this. Hopefully, I would have dealt with all the other issues that the committee would like to have covered by the presentation. We were asked to deal with the issue of the amended accounting policy. I think, Chair, the reality, we didn't know whether we must come and present the whole accounting policy as it were, but the change in accounting policy we have not done in the previous financial year of the year 2023-24. The accounting policy was changed as per the correspondence we have sent to the committee. It was changed in 2020-2021 on the basis of what we found at the time, which is the fact that RAF remains a social benefit fund, and that when we took over, Chair, there was use of what is called IFRS 4, which is accounting for insurance contracts. And that's the difference we have, of course. And you would see, Chair, that it permeates across, and that is what is affecting our audit outcome, because the difference we have is between us and the AG is that they want us to consider our claims as insurance. And that, of course, affects where the liability is then recognized. Because if you are insurance, you recognize the liability once an accident happens. And as it is, Chair, in terms of section 17, actually probably 18, 19 of the RAF Act, together with section 21, 22, 23, and section 24, you would see that there are exclusions. And those exclusions must be taken into consideration when you recognize liability. I think we'll We'll go further, Chair, if there is a need, but all we are saying is that there is that challenge we are having in recognition of the liabilities. And I think it's further explained, Chair, in our letter that we sent to the committee. I don't know whether committee members would have that. So let me jump off, Chair, out of this one and go to the financial performance. What you'd see, Chair, is that we would want to, our financial position, Chair, has regressed quite slightly, because if you look at our net liability position, it has increased by about 1.5 billion. You would see that our liabilities have grown, certainly from a short-term perspective. We have reduced that liability to about 8.3 billion, and you'd see it as we go, Chair, into other statements as we move. We have managed to, Chair, balance this, and I think it's important that when we go through this, Chair, you must understand, the committee must understand where we come from. The fuel levy has remained constant, so over 3 years. So in real terms, actually, it has reduced. But what we are having is a situation where the fuel levy has remained the same, but your cost structure has actually increased, at least from an inflationary point of view. And I think that when you look at this performance, it must be seen in that context as well. And what we are trying to do, Chair, is also balance a couple of things. The RAF has got a particular problem. Its problem, from a financial point of view, is that its solvency has always been a problem, but the biggest issue is its liquidity. How does this come, Chair? And I think it's important that when the committee looks at this and the interventions that the committee would like to help us with, it must include some of these issues, which is the fact that we receive our fuel levy every month. So, and we pay in lump sums. So, if someone gets injured today, Chair, and this person is 40, we must take care of that person until the person is 65. But we then pay that whole amount today. For the next 25 years, this person must have this money to take care of themselves. Now, this creates what we call an asset liability mismatch in the profile, because we receive our money every month, we are paying over in lump sums. That creates that squeeze, because you then give someone, let's just say 10 million, to take care of themselves for the next 25 years. But when you collect this money, is the R2.18 that you'll be collecting each and every month. And that creates a problem, as it were. The Deputy Minister is correct. It's the only form of revenue we have, save for what we would have as interest income, which is very minor. And that creates an issue, Chair. The second part that we need to balance is the fact that we have got a backlog, and that backlog, the biggest part of that backlog, does not have the information we require to make offers. The RAF Act is such that if someone, Chair, today applies or claims from the RAF and does not attach the required information, and the RAF does not get the opportunity to validate that claim within 60 days. Section 24(5) says it's valid in all respects in law. So we arrive, we find this backlog of about 300,000 claims. 93% of them do not have all the required information. But you can't dispute those because they are valid in all respects in law, because now 60 days has passed. Now, we continue to have that because when we reject them, as we speak, you'll hear, Chair, about the draft Form 1. You'll read about it a lot in the media, because we are saying give us all the information. But when we reject it at the Road Accident Fund, is then posted, Chair. Because in terms of the Road Accident Fund Act, we receive this either through you handing it in or you posting it on registered mail at the post office. When we reject them inside these days, we have seen a massive increase in people using the post office. I'm sure the people that send this rough thing are the biggest people that pay the post office these days. So we are seeing these things coming through the post office. And the question one must ask themselves is whether people are interested in actually resolving the issue about the claims, or they're interested in them being valid in all respects in law, regardless of whether these claims have all the information. I think that becomes important, Chair, in looking at this work that we do. Let's go back to the statement of financial performance. I'm just giving a perspective, Chair, because as we go along, you need to, when you look at this financial performance, that must be. So from the revenue from exchange transactions, Chair, investment revenue has increased from 286 million to about 702 million. The net revenue from fuel levies has increased slightly from about 48.4 billion to 48.6 billion, Chair. This is something that, Chair, we sort of say it's a success from the implementation of the work that we have done. If you look at the claims expenditure, Chair, because out of the 48.6 billion we have covered, the claims paid is sitting at 45.1 billion. When we arrived, Chair, in 2019, and we were told to take care of this fund and try to turn it around, this figure was sitting at about 27 billion. Why was that the case? Majority of this money was being used to pay what we called administrative costs. And in schemes like this, our view is that when you drive efficiencies, you're gonna have to, out of every rent you collect, pay more money to the claimant than actually pay the support structures that get to effect this. And you'd see this, Chair, because we at 27, I think it was 27 billion at the time, we were collecting about 43 billion. 17 billion was actually going to administrative costs. And the travesty of it is that 10.6 billion of that was going to legal costs. This amount had grown, and we'll show you the trajectory that was expected that it would be growing towards. And it's at the center, Chair, of the battle that the RAF would always have with lawyers. This 10.6 billion. 3.8 billion of which used to go to what we called an internal defense panel. 6.8 billion was spent on plaintiff attorneys, on what is called mostly party costs, if you look at it. And our issue was that that is just simply not efficient. Because when we looked at the certain studies that were done, one was done by Professor Klopper, it indicated that 99.6% of the time, these matters never come in front of a judge. So it then meant that all these matters are settled at the doorstep of the court, probably on average 5 years down the line, with all those costs that have been incurred. But we also got the judiciary criticizing what we were doing at the time, because their view was that who were defending meritless cases for the sake of it. And we were even accused of actually using this as a cash flow mechanism to just defend for the sake of that, just kick the can down the road. And at that point, we were also having a problem that we owed a lot and our short-term debt was getting out of control at around, I think it peaked at around 19 billion and it was at 16 billion at the end of that year. You would see how we have reduced it, but we'll show you, Chair, how we have applied ourselves to that. Now, we also picked up that unlike other entities that, our sister entities, we didn't have the problems that they had. One of the biggest problems that you would find in entities is the payroll, which in most instances is so big that it disturbs and is part of the biggest part of the administrative costs. We didn't have that problem. And then we then implemented other things, including getting rid of the defense panel. And of course, then working with the Department of Justice to assist us in actually defending the matters we should defend as we move forward. And of course, we also looked at whether we can't introduce digitization in the process. But that digitization of the RAF, Chair, would need a legislative change. As I say, Section 24 says you must hand it over by hand at our regional offices or the head office, or you must post it. So it must actually be a physical document in terms of that. It is the only act, Chair, that I know where a procedure is actually hard-coded into an act of parliament. Usually, these things are in regulations, but in the RAF Act, it sits at Section 24 of the Act. So this must be seen, the total expenditure set at 48 billion. And of course, we had a deficit of 1.5 billion coming from 8.4 billion in the previous year. Here, Chair, we're trying to balance because at the end of the financial year, we don't want to have a big surplus. You would see that in the year ended 2021, we had 1.7 billion surplus, and we were quite criticized quite heavily for that. And we understood why people would criticize for it, because in the fund, we were just trying to break even, Chair, as it were, because the money we receive, we pay out. The claims liability, Chair, next slide, it's, you would see that the requested but not yet paid has been quite consistent. As we said that it had been 16 billion when we started, and we are sitting at 8.2 billion or 8.3 billion there, 8.27 billion to be precise. We do this by actually taking the money that we are saving on legal costs. About, you'll see, Chair, about 6 billion a year in legal costs, and we take this and then we use it to pay claimants. The offers not yet requested for payments, about 27 billion in that year, and this is also driven by our backlog campaign that we are running to try and balance that. But we must say this, Chair, as we go forward for understanding. We need to, we have got cash, we have got a backlog, we have got cash constraints, we have got a backlog, we now have got claims that are coming in, and we want to settle them in 120 days. But there are claims that are sitting in the system that have been there for a long time, so you need to balance all that at the same time. And you would see in our targets that we are trying to say 120 days, but we are trying to also make sure that we deal with the backlog. But we need to balance the cash that we have on hand. Because if we run a quicker backlog campaign where we can get all that, but then the main, that's a problem. Or and we settle all matters within 120 days, we'll sit with a big short-term debt that says you have now finalized these matters. You need to pay them. You have finalized the ones that are coming from the backlog. You have got to pay them, but you are receiving only 4 billion each and every month. So you need to make sure that we balance all those. And that's why you would see that we are quite cautious in terms of how we balance these resources so that we don't actually run out of money, as it were. And we keep on trying to reduce the short-term debt as we go along, which you would see that we are quite successfully doing. The claims expenditure, as I said, claims paid about 45 billion. And of course, the increase in the provision of about 3 billion thereabout, and the increase, a decrease in RNYP of about 1 billion. And this is where we are saying that we are actually using the money to try and reduce the short-term debt that we have. I will then go, Chair, to the audit outcomes. As the Chair would have already alluded.
Sorry, Mr. Lutsalo, can I interrupt you? Can you go back?
Yeah.
One slide more. Okay. So this is just clarity seeking. Yeah. So your categories are claims requests. Can you describe those for the committee members? That's important, so that we understand what it means. So the claims requested but not yet paid. Has that matter been to court necessarily, and there's a sort of a conclusion in that respect? Is it a claim that settled in terms of the normal course? Just want to understand. And then the offers not yet requested for payment, what does that mean? So I'm just trying to de-jargonize here so that the members are, if you can. And then, because there are two categories here, right? So if you go to the next slide, there are 3, right? So you've got your claims liability 2 categories, your claims expenditure 3 categories. So can you just help the members with understanding those 2?
Yeah, thanks, Chair. Claims requested but not yet paid is money we owe to claimants that is in what is called RNYP, meaning everything is concluded. If we had the money today, we'll pay all of that money. So usually it's about 180 days, the age of it, because we have asked the court in terms of 45A to suspend all these orders that are in line with that for 180 days. So we've got 180 days period to pay this down. So over a period it goes, we pay, then it increased by all the settlements that we have done, either from settlements that we settle directly or court orders. So if we had 8.2, if rough closes today, let's say, that's the amount will remain owing plus this other amount that is offers not yet requested for payment, but they are in the system somewhere.
Okay.
Yeah.
I've engaged with this quite a bit, right? I'm going to ask you some stupid questions. This is being kind of broadcast to the public. So I'm doing this so that we understand. So the claims requested but not yet paid. In other words, the matter has been finalized. You know how much is due to each claimant, but it is not yet paid.
Yes.
So in terms of the cash in the bank and the entries in this financial year, it's in terms of your cash flow management, that 8.27 billion, if you had done this today, you have to pay this between now and 120 days time, which is 4 months.
180, yeah.
180, 6 months. So that 8.27 billion has to be paid within 6 months,
yes,
right?
Yes.
I am also assuming that's a moving number.
Absolutely.
So in other words, tomorrow you get more, and the next day, and the next day, and the next day. So I'm asking so that we understand, right?
Yes.
And at another time, not now, we will then ask you to kind of take us through that process in detail.
Okay.
Right. Yeah. Then the offers not yet requested for payment, are those matters finalized? Why is it so? The one is claims requested, the other is offers. So why is this an offer and the other one is a claim? So I said I'll ask some stupid questions.
No.
So that, everyone follows properly.
So on our offer management, Chair, we make offers because, let me explain it like this. So it's quite, you pardon me, Chair, it's quite an upset situation in a sense that you are suing us to get your benefits. So you start a process. It's like a suing process where you say a letter of demand. If you don't, then it's followed by summons. So the very same thing happens in the RAF system. So you then say, I want this much, and then we make you an offer. Let's just say you say, well, for this, I think you owe me 6 million. We say we think it's 4 million. We do the calculations. We then give you an offer. We say a 4 million offer. You have not accepted it, but we have made an offer. So you can accept it at any point during that point. So once you accept it as an offer, it's now a settlement. That settlement goes to the RNYP.
I see. So in other words, your claims department. Can you just switch off your mic so that So in other words, your claims department or division has made an offer. Honorable Skosana has not yet accepted the offer, and therefore the claims team has not yet requested finance to put that through the system for payment. That's what that means. Okay, we can move on. Okay, we can move on. Get it.
Now, Chair,
sorry, go back to the next one then. There was a slide. There you go. So okay, that's fine. So take us through that and then go to the next one.
There is just the claims paid, Chair. And that RNYP, as we said, has reduced. And then, of course, the increase in the claims provision as a result of more claims being there and offers being made. And we make a provision for that in the liability. So, okay. Now, let me jump out of that, Chair, to get to the audit outcomes. As I said, the Chair has said that there was an area, which is system modernization, where we are trying, as I said, to digitize the space, and they came and audited that aspect. But from a financial statement point of view, Chair, as we said, that we still have that outstanding issue about our classification of whether indeed we are an insurer or we are a social benefit scheme. We have that issue around the recognition and from a point of the liability perspective. As a consequence, we have got this adverse opinion. And from an annual performance point of view, the Chair would see later what we have. We have a clean audit from that perspective. System modernization is also green. Compliance with legislation as a consequence of that financial statement and the misstatements thereof that the AG disagrees with us on. We have got material findings on our financial statements. And then the procurement and contract management, it's green. Expenditure management, green. Asset management, green. Consequence management, green. And strategic planning and performance management also being green there, meaning that it has been stable, it has not moved since the previous financial year of 22-23. In the next slide, Chair, we are just showing you what I had said that is the context that we want to provide, which is in real terms, we are sitting at about 158 because the fuel levy has not changed in a while. And this, of course, creates issues around the squeeze that we are having from a liquidity perspective. But, Chair, I want to emphasize this. This is not what we are saying, because half the time when you raise this, people say, they are saying there must be an increase in the fuel levy. We are saying we have this fuel levy. It may not be enough, but we must use it more efficiently. Using it more efficiently includes a lot of other things. As we sit here today, any billionaire that can crash on our roads, Chair, can claim from RAF. But this is a social benefit scheme. So there are people that we think must be excluded from this. any foreigner walking our roads gets to be paid by the RAF, something that in this whole wild world is not done anyway. And that for us, it's an issue. The regressive way in which the scheme works is such that if I get injured, Chair, today, same injuries as my helper, same accidents, same injuries, I will get more money because it is based on the earnings capacity that I have. And I have a higher earnings capacity than her. So it will so happen that I will get more money. So it's a regressive way of looking at it. I don't even think I should qualify to actually claim from the RAF. But what is worse is that for me to get those benefits, I must sue. And if I have got to sue, I've got to have the money, Chair. You can't sue someone when you can't pay a lawyer. And I will be able to do it. My helper may not be able to do it, except if he then agrees with a certain lawyer that no, go and do it and then come back in terms of Section 19C, which of course means that she will get 25% less. That is if she'll get that money anyway, with the experience that we have with these lawyers as it is. But it's how the scheme works. And we want to say all those things in our view are inefficiencies. You are actually covering in a social scheme people you should not cover. And we know, Chair, why lawyers would always want to be retained in the scheme. They make money. But it's us, the people that can afford this thing, that we don't want to be seen to be coming to RAF and submitting our claims. So we hide behind lawyers. You would never see a name of a person who's getting paid, because this billionaire, we might have paid him, you might have seen him, but the person in front would have been a lawyer. So that's the problem that we are saying. So I want to keep it quite clear that it's not what we are saying, that we want an increase in the fuel levy. Not that if we get it, it won't be a problem, but all we are saying is that with the issues around cost of living and all that, we can live with this if we then make the efficiencies necessary. Now, the next one is the issue around the RNYP, Chair. We have already said that. You would see, Chair, that if we did nothing about this, where are we? No, it's different. Okay, all right. No, if you look at that, Chair, you'd see that in this financial year, we would have had an RNYP of 51 billion if we did nothing. The do nothing scenario was 51 billion. It was what is called day zero in the RAF, where our whole revenue would have just simply been wiped out by the RNYP. We would not have been able to manage it and pay. And as we say, it is now sitting at 8.2 billion because of the interventions that we have made. And that becomes important in looking at whether the model works or not. Next slide. Here, Chair, we look at this versus the fuel levy. And that's why we are saying, notwithstanding the fact that the fuel levy has not increased, you would see changes in that space, as it were. Next slide. I think. Oh, that's the vetting of executives. And this, Chair, is what we are asked to do by the 6th Parliament. And we have this process ongoing. The executives are there and they are being vetted. I think most of them have gone through. I know that I've been interviewed by the SSA on most of the executives, and they are going through that process. And once that has been finalized, of course, then the vetting would have been finalized, as it were. I hope, Chair, we have touched on the issues that needed clarity. And if there are questions, Chair, we'll be able to take them. Thank you so much.
Thank you very much. Board Chair, Deputy Minister, do you have any additional comments?
Let me defer to the chairperson.
Chairperson, I think we'll take questions and then we'll deal with them. Thank you very much.
Thank you very much, Honorable Deputy Minister, Board Chair, and Chief Executive, Mr. Litswalo. So, I'm going to make some comments arising out of what you've shared, what we've considered by way of historical discussions in various committees in Parliament, including this one, over time, and preface my points in this way. And I will once again reflect a general attitude first. There are several entities or legislative sort of outcomes that create an accounting and financial liability problem across the system. The medical legal claims pose a similar problem as a road accident fund that you've outlined. I'm saying this to say that means I agree with the Deputy Minister and the Ministry, and I agree with you. There is an issue with the funding model. So this committee tries very hard all the time to do the right thing. So in other words, we are not going to butcher you over a legislative outcome. Right, so I just want to make that clear, that we recognize, and the job of Parliament is to amend legislation when necessary, or to ask the executive to engage in certain processes that solve the problem. So it's clear, and Deputy Minister, I think you said so, that the revenue stream of the road accident fund needs to be resolved. There are other policy issues as well that may be necessary, and I don't want us to, so I'm just offering this now so that, you know, as the committee members ask questions and I ask questions, because I've got quite a few myself, you all understand that, at least from the chair's perspective, we recognize a fundamental problem. The second issue has to do with the manner in which the state's responsibility is recognized in financial terms. It arises with medical legal claims. Do we pay you a lump sum now, thinking that you are going to live for 100 years, or do we take care of you on an ongoing basis, and some of that happens in the state system and that kind of thing? And that there are some links between the two, at least systematically, because it might also be that some of your claimants, all the state needs to do is to accept responsibility for their care in state institutions. We don't need to pay them cash, as an example. So I'm just saying that we recognize the legislative and policy issues in play, so that it does not come across that the committee does not recognize that there are those issues in play. That said, one of the reasons we asked, and we're referring to the same thing that you traversed, Mr. Litswalo, which is a matter in litigation. So what happened is that the Auditor-General gave us a view, and the reason that question was asked was to also give you a chance to ventilate it for the committee to understand, so that as we assess what position to take on the issue, we've heard from the AG and we've heard from you. So the first thing I'm going to do, and we did the same with the Auditor-General, is I'm going to describe the problem in summary, just to make sure that we're on the same page, and you then tell me whether that's accurate or not, and then we'll go to the issues in dispute. So that's one aspect that we're going to deal with. The second is, it relates to some points that are not explicitly covered in the presentation, which is the outstanding claims, the backlog, and the impacts thereon into the system, including the court backlog that we have. So there's that issue. There are other financial issues in the financial statements, and then we'll deal with the vetting of executives. And finally, what we will do then, we'll be in a position after that conversation to start saying what our next conversation looks like, so that there's certainty in that respect as well. So let me describe the problem. So the first thing I will make, and it's got to do with how you framed it. The dispute is whether the road accident fund is a social benefit scheme or an insurance-like product. Is that true? Because an insurance pays you now, and we give you your money and off you go. We don't pay you over time, right? But anyway, at the heart of the dispute, which is then reflected in the accounting treatment that is applied in the recognition of claims, is whether this is a social benefit scheme or it is an insurance-like a system. Would that be accurate?
Yes, Chair.
It would
Whether we are a social benefit
Yes.
and whether we are an insurer. Because insurance-like does not exist, Chair,
Okay.
in literature. Yeah.
Yeah. No, I'm saying insurance-like in the sense that we don't pay you premiums, but for all intents and purposes, you are an insurer.
Yes.
Right. Okay. So that's step one, and I'm hoping we can then work together in the rest. That means the dispute between yourselves and the AG is at which point you recognize the claim in accounting terms such that you make provisions, right, in your financial statements for those claims. So what you are saying is that it needs to be a validated claim first, and then we'll enter it in our books. If it's not, then we don't recognize it and we don't reflect it in our books. Would that be correct?
Indeed, Chair, but I think one of the issues must be canvassed very clearly. Once you say insurance or social benefit, then there is a standard. I think we must start there, because you see, if we move past that, we would have missed the opportunity of understanding what the crux is. Because if there was...
I'm getting there.
Okay, sure.
I am getting there. I'm just, so I said I'll ask a few stupid questions. Okay. So that's the second part of it. And I'm not wanting us to replicate the work of the courts here. It's just for the public's understanding and everybody's. Then there are accounting standards adopted by both our government, the Accounting Standards Board, and the Auditor-General that determine what accounting treatment must be given depending on what your view of the scheme is. Do you think it's an insurer or do you think it's a social benefit scheme? Would that be correct?
That is correct, Chair.
Final point. So this dispute has gone through the courts. How has that litigation gone so far? How have the courts decided?
The courts have said that we are an insurer. At least the North Gauteng High Court, Chair. On this matter, on us versus the AG, they said we are an insurer.
So in other words, they've agreed with the Auditor General.
Yes.
Was the matter not before the Supreme Court of Appeal at some point?
Yeah, Chair, we have taken the matter on review for obvious reasons, because we don't think that that is the case. And it is in front of the SCA, and we have now asked for reconsideration by the president of the SCA, because they did not look at the matter. They told us that we did not meet the requirements of a special appeal. That's what they said. So we have asked for reconsideration of that.
Apologies, Chair. I would regret for us to continue on something which may be factually not correct. The AG does not set a standard, because in the question you asked previously, you listed. So I just thought, for the purposes of checks and balance, that we do not draw the AG into being a referee and a player. They audit against the standard. Thanks.
Okay, so I think I should have framed that correctly. So the AG audits against what the ASB has set out, and I need you to correct me. The ASB is the Accounting Standards Board. There would then be guidance from National Treasury. Am I correct? In terms of how these things are, so there are two, right? So the AG then assesses your finances relative to the two. AG, I'm looking at you because this is important. Okay, Honorable Atkinson?
Yes, correct, Chair.
Chair, sorry, I've got something here which might provide more clarity as far as the legal cases are concerned. And this is in the High Court of South Africa on the 24th of June in the matter of the Road Accident Fund and the Auditor-General, the Accounting Standards Board and the Minister of Transport. And it's ordered that the application for leave to appeal is dismissed with costs. So it basically ends there.
Thanks, Honorable Atkinson. So let me summarize. I'm just wanting us to catch everyone up to our conversation. So the history of this, as I've been able to see, so there was an initial High Court application that went as a road accident fund. Then there was an application for leave to appeal at the High Court. The High Court refused. Would
Yes.
that be correct? They did
Yes.
not hear it.
Yeah.
The Road Accident Fund then approached the Supreme Court of Appeal. Correct? Already, because you used
Yes.
the term reconsideration.
Yes, Chair.
And the reconsideration application is done. You petition the judge president of a court following a decision of that court that the litigant believes was not right.
Correct,
Right?
Chair.
Would that be correct? So I just want to say this. So the High Court considered the issue. You appealed for leave to appeal. They refused. You went to the Supreme Court of Appeal. They've turned you down. Then you are now petitioning the judge president
Yeah,
of the
correct.
Supreme Court of Appeal to reconsider the matter.
Yes, Chair.
Right. So far, what we know is that the courts have agreed with the AG at this point. That's the record that we have. I'm saying this, Mr. Litswalo, so that it's important that when we speak here in committee, you've used the term social benefit fund.
Yes, Chair.
That's not decided anyway. Is it?
It is, Chair.
By who?
By the Constitutional Court in LSSA versus the Minister of Transport and others, and recently by High Court, Antwerpen versus the Road Accident Fund. And this was on the, I just want to get the date. This was on the 29th of July, 2024.
So what I want to say, Mr. Litswalo, is this, again, I will, so what happens in the course of litigation? The courts apply the law to the facts. Quoting an authority in litigation is not the same as a decision in your favor. In other words, what we have on record right now is that you still have not won the case. Have you won it?
Absolutely, Chair, which is why we are asking for reconsideration, because we differ with the views, and the courts have always found to have erred. If you look at some of the cases that we have won them on appeal. In fact, most of our cases were won on appeal when we went on appeal, and that's why we are saying, Chair, it is a matter. You are asking whether there was a consideration of whether we are a social benefit fund, and I said the Court has found out that we are. It is a thing that Museneke, Justice Museneke did in the LSSA versus the Minister of Transport and others.
So, Mr. Letswalo, the substance of my question is in this matter, have the courts ruled in your favor in this litigation?
No, Chair.
Thank you. That's important to place on the table. You therefore cannot describe this as if it's a settled matter arising out of your litigation. What you have is a view informed by the authorities you are referring to. It's not a specific decision of the court. And this is very important. I'm not fighting with you. I said initially that it's important that we are candid with one another in the course of our so the way I would frame it is that I would have said to the committee, our view is that this is a social benefit fund, right? To the extent that I'm going to refer it as such, the dispute is ongoing. However, this is currently our view. As we sit here, you are still legally, as far as this dispute is concerned, and in terms of the accounting treatment, you're still regarded as an insurer until this litigation has been completed. Because the issue here is what accounting standard applies. So I'm saying this so that we do not go off at a tangent. The Honorable Sana, I'm going to come to you. I'm getting clarity, seeking questions for now. As I always do, I give the members a chance to ask questions. And I do this every time, Honorable Skosana, where I ask for clarity. And once that is done, I then hand over to the members. So all I'm saying, Mr. Litswalo, is that the litigation continues, right? Even though, right, and my next question is whether you have actually filed your reconsideration and so on. But the point I'm making is that the litigation in substance continues, right? The matter will be settled at some point, either in your favor or in favor of the Auditor-General. And therefore, the matter remains undecided. It has to be, because the litigation is ongoing. It is undecided, yes. Right?
Yes, Chair, but I think, let me clarify one aspect, Chair, which becomes very, very important. The decision of whether we are a social benefit scheme or not, it's a matter of classification. Classification in South Africa is done by the Public Sector Classifications Committee. The Public Sector Classifications Committee in November 2022 reaffirmed the classification of RAF as a social benefit fund. Now, where do you find this classification, Chair? 1998, South African Reserve Bank.
Honorable members, Mr. Litswalo is on the floor. Please just lower your voices.
South African Reserve Bank, Institutional Sector Classification Guide, RAF, Social Benefit, Social Security Fund, they call it. FSB, Directive 1, February 2011, fundamentally Social Security Fund. The Prudential Authority, who is our regulator, classifies us as a social benefit fund. In July 2024, the new Institutional Sector Classification Guide of the Reserve Bank, the latest one, RAF, Social Security Fund. So all we are saying, Chair, is we are saying this convinced by those authorities that that's what we are. And all we are saying is that anyone who says we are something else must actually produce that evidence. We are still waiting for it, Chair.
And I'm aware that these matters have been traversed in the same court action you lost. Okay, thank you. All right. So I think I'm hoping we've kind of come to a level of clarity, and I'm looking at the members as to where the dispute is, right? So it has been to the High Court. The High Court has agreed with the Auditor General. Then the RAF petitioned the High Court for leave to appeal. The High Court turned that application down. The matter went to the Supreme Court of Appeal, and the Supreme Court of Appeal turned the Road Accident Fund down. The matter is now going to be with the Judge President of the Supreme Court of Appeal to ask the Judge President to reconsider, right? So that the matter is ventilated, because it was dismissed without a hearing. Would that be correct? Thank you. So that's where we are. The reason I'm saying this, Mr. Litswalo, is because I don't want us to try and replicate the court by having an argument here. The matter is now in the court. We will wait for the court outcome. However, this information and this process is important in our future consideration of the AG's position. And that is why I wanted this matter litigated, sort of outlined here, okay? I don't take a position as yet, okay? At least in as far as what the committee therefore needs to do about the outcome. And you are correct, you referred to a information that you sent. I have sent that letter, this is for the committee members, to ask for more information so that as we work on our program, it's an informed process rather than. So that information has been furnished by the Road Accident Fund, and thank you for that. So I wanted to do this because I am going to open the floor to members for their questions on the entirety of the presentation. But because we did not kind of go through this, I wanted to make sure that we are all on the same page. I am just going to ask the AG team, is there anything that is inaccurate that I've said here? I don't want us to mislead the public.
Person, I would also request you note the chair as the accounting authority. I think she's got responses she would like to give.
Okay, no, thank you. Okay, so nothing inaccurate so far. Okay, thank you so much. Chair?
Thank you, Chair. Chair, I'd just like to add to what the CEO have said. I think one critical aspect around this dispute, this is a technical matter. I think you've summarized it very well. But at the core of this is that there is no appropriate social benefit standard to be applied around the recognition of liability, claims liability in this country. And in that absence, the accounting setting standard from 2004 has been in the process of drafting the same. And I always say that we need a technical solution irrespective of what's going on, with the courts. So the sooner we get the technical standard that is relevant, then this matter would be technically resolved. So I think we need some sort of support in getting the ASB to fast track this process, because it cannot be that it takes more than 20 years in this country to develop an accounting standard. And secondly, there's another aspect in the classification. There's 4 public entities that the South African Reserve Bank have classified as social benefits funds: the UIF, the Compensation Fund, and the CCOID, which is the Compensation Commissioner for the Mines, for diseases in the mines. And all these entities are not requested or required to use an insurance standard. Only the RAF, which is a major inconsistency and an anomaly in terms of accounting and applying these standards. I just wanted to add that. Thank you.
Thank you very much. And Chair, I'd like to assure you that I do not regard this matter as spurious at all, right? Earlier on, I referred to legislative and other issues, right? So I recognize that. But I want to ask you, Chair, since you dealt with the matter, for clarification again, typically when a standard or similar, so when there's a process that is in play to get to an outcome, there is guidance that is provided as to how entities must, in the meantime, what is the applicable standard in the meantime? Have you received such a guidance from any authority?
Yes, Chair, we have. We started with the very ASB to get guidance from them. And they gave us guidance up to a point where we, as a board, we are sure that we're on the right track. And we also benchmarked with other accounting firms locally and internationally, because it wasn't an easy decision for the board to take at the time. We had to make sure that we follow the GRAP framework, which is the accounting framework in the public sector, and make sure that we also follow the directives that are issued by the ASB, as well as engage with the Office of the Accountant General within National Treasury. So that those discussions ensued up to a point that we were assured that we're following the right direction. But then when we were doing that, then the AG came out of that process, and then we were left with a dilemma because the technical matter hasn't been resolved. And I think that's why the matter ended up in court. So yes, we engage with all of them, and I think we've shared that information for the committee so that they understand what was the due process. Thank you.
So in substance, you are therefore saying the Treasury and the ASB has agreed with your approach? Chair, Chair, I'm asking you. So in other words, in this dispute, you've got the support of the National Treasury and you've got the support of the Accounting Standards Board.
When we made the decision at that point in time, they did. But then subsequently, when there was pressure, then, you know, professionals changed their story. But at the time when we're considering changing the accounting policy, in our engagement, they gave us that support.
What is their position right now, Chair?
As I said, they've since changed their position, I must state that.
So they agree with the Auditor-General?
Yes.
So let me say once again, I'll say this the last time, colleagues. It is very, I spoke about candor earlier on. We must not frame things in a way that appears to give a certain impression. Because this exchange, Chair, that you and I have just had now, if I had not asked the final question in the matter that I did, the members would have been none the wiser as to what the exact position is, because it gave the impression that Treasury and the ASB have agreed with you. So the reason I've been asking these questions in the manner that I'm doing is that it's not just about our conversation here. The public has to know what the state of affairs now. I have not expressed myself, for instance, on what I think about, you know, the dispute itself, because it's in play. But it's important, Chair, that when we give answers, they are truthful. Please. Thank you. I'm going to give you an opportunity to ask questions. Honorable Neil May has to leave at 11 for an important personal matter that she's got to attend to. She has spoken to me. I am going to favor her with the first opportunity to ask a question so that she can then leave with us. So please bear with me. You know, I have done the same for other members who had an emergency who have had to attend. So Honorable Neil May, let me ask you to ask some questions. Thank you.
No, good morning, Honourable Deputy Minister and your team present here, the chairperson of the board, and your team that is present here. Good morning, colleagues, and our chairperson here. No, thank you very much for your presentation. And listening to the deliberation that was presented here, my thoughts are that this is the public's money. That is being debated in the sense of how classifications are done, should it be done. And looking at the compliance and the non-compliance, what was the view of the board during all this time with regards to the non-compliance? I'm looking at, we also do research with regards to the standards, the Public Sector Classification Committee. And in all of that, basically, they were saying that, that the PFMA is still our guiding document of government. You have a Minister of Transport that you also need to confer with. Why then are you in opposition to government, if we are one government, surely there should be a deciding factor that government is leading. So the Department of Transport should be leading in this dispute, because the money that is being used legally is the public's money that should rather be paid out to the claimants. And it's making a cottage industry for lawyers. And I love that term that came up when we looked at the medical legal. We have a cottage industry of lawyers. The only people that are benefiting here is the legal fraternity and not the claimants. And at the end of the day, we represent the people of South Africa. And to listen to how that the road accident fund is on its own road and not in unison or in sync with government, with the legislation of government, with the Department of Transport, and taking into account the people of South Africa. And that is where I'm actually putting the ball in the board's court. Where are you on all of this? Why are you then not conferring and guiding? Because at the end of the day, the buck stops with you. The non-compliance, the lack of funds, the corruption, the whatever has happened. If you look at the reports from the SIU and you look at the challenge, since when does a body take the AG to court? I mean, we are all one government. And this is the question that I have in the sense of looking at the presentations and going forward. Thank you very much.
Okay, so what I'll do so that you can go, Honorable Neil May, I will ask the deputy, I mean, it's up to you, Deputy Minister and Chair, to say who deals with the issues, and then we'll release you, Honorable Neil May.
Chairperson, if I may beg your indulgence, that the board and the executives will field the questions. I will have one or two comments at the end, unless there is a direct question to myself. Madam Chair.
Thank you.
Thank you, Chair, and thank you, Member, for that question. I'm going to answer the question from the board perspective, and then I'll allow the CEO to deal with the specifics. Honourable Chairperson and Member, this matter is currently, I mean, up to this stage, as a board, we are very clear that we needed a technical solution. And the dilemma that we're facing now, in fact, we are re-looking at the matter with our new minister and deputy minister. We are currently discussing that, and we're saying the board is not disagreeing with the direction that the minister and the government is taking us, but we're saying there is a technical vacuum in terms of how are we going to account. So we need a technical solution in changing and transitioning in this process, because the standard that we are expected to go back to, it's called IFRS 4, has been discontinued and has been replaced by IFRS 17. IFRS 17 talks to commercial insurers with insurance contracts as well as insurance license, which we are not, we don't have those. So we're trying to find a solution to deal with that vacuum in terms of where do we go back to, because there is that just vacuum that we just need direction to take, and then basically we'll be in agreement, because then we still have to account in terms of our liability going forward, in terms of our financial statements. So we are currently dealing with that matter. We understand the pressure and the expectations by the current shareholder. Let me allow the CEO to take the rest.
Over to you, Mr. Luso.
No, thanks very much, Chair. Look, I don't think that we will ever be recalcitrant to the point where we ignore what the shareholder says, or Parliament for that matter. I think one of the most important things in taking care of this kitty is to understand what the ramifications of insurer means. And I think we will share with you, Chair, the letter the memo of the ASB to its own board on the 22nd, I think in 2020, I think it's 2021 in September, of what it means. Once you say we are an insurer, it means we must be fully funded. Fully funded means you must then get some 300 billion from somewhere, and that must be understood in that context. The second part is, it is not our intention, it has never been our intention to take the AG to court. It took a long time and various engagement before that happened. And one of the things that we tried to do, the previous minister had asked us to actually engage the AG on these matters. The AG told us that even if she was to agree with us, she's funtas officio, meaning she can't change her own decision. It's only the court that can change an AG decision as a Chapter 9 institution. So it must be understood that there were engagements, there were attempts to try and solve these matters outside the court process, but it's only through the court that we'll get that decision. And as the chair says, it's a technical matter. For as long as there is no standard for social benefit, that's where we sit and settle with this problem, Chair. Thanks.
Thank you very much. Honorable Neil May, so you'll be free to leave when you need to. Thank you very much for coming nonetheless. Thank you so much. Okay, so the other members, I saw a few hands. Honorable, in fact, let me do this. So, yeah, I will do that. So we'll do this as we do customarily. There's an appeal from my right-hand side here. Okay, let's do that. So let's do that. Can I ask members? So I want us to be able. So after this round, we are able to take a comfort break and then come back. So can I ask that we are concise in in our questions? Thank you. Honorable Kubeka, you are recognized. And then it will be Honorable Skosana, Atkinson, Madlala, Maduna, and Bloss.
All right, thank you, Chair. And greetings to the Deputy Minister, Mhlonishwa Jaman, and the RAF team, and greetings to colleagues as well. Apologies for what happened just before when I came in. I think we would like to appreciate the report by Mr. Lotswalo. Thank you. I think from where we're sitting, it's important for us to highlight how incorrect it is for an issue like, or a place like RAF to have issues where we need to debate about who's equal and who's not equal in the country. Like the CEO was just saying, we have issues where, if, for instance, he is claiming he ought to get a higher amount, and then if his the lady who is helping him at home is claiming they will get a lesser amount. That is so incorrect on so many levels. It's not correct that people are still regarded as unequal in this country. That's point number one. I think point number two is we need to find a mechanism to help the poor in the country that are exploited by these lawyers who claim up to 25% of claims from people who are unable to help themselves. I don't know what we as a portfolio committee can do, or what minister and the office of the minister and or the board can do, the board of RAF that is, to look at how we can stop this exploitative behavior from these lawyers, because genuinely it's not right that if someone can afford to pay lawyers, then they have the upper hand. And if you can't afford to pay for lawyers, you've got these unscrupulous lawyers who will take people for a ride, and they will take 25% of a claim from people who definitely need it. And then I think what I would like to know from, again, this I'll ask to Mr. Lotwalo, is how many of these claims are claims due to and are paid out to illegal foreigners? And then again, how many of these claims are due to and are paid out to illegal foreigners? So basically, I would like to see that from the presentation that we just got, of the claims that are there, how many are for legal foreigners? How many are for illegal foreigners? And then on that note, I would also like to know, why is there no law that would prevent foreigners, whether they're legal or illegal, from claiming from RAF? It's really bizarre that when you enter other countries, when you go into other countries, as whether you are going on holiday, you are traveling, you are working, you are forced to take insurance at the port of entry. But here in South Africa, people, whether they are here legally or illegally, are able to access benefits that they should not be entitled to. It's incorrect. It's absolutely incorrect. And I think that I'm happy to see that Deputy Minister is actually agreeing on that one. I would really like us to have a look at that one. And then it's 2024. I think it's really a dare I say in this house that it's ludicrous that we still have not cleared this confusion. And I think lastly, whether RAF is a social grant or an insurer, I think we need to get that clarity soon. We need to clear that one. As much as we may hold our own views, we need to clear that one quickly. I personally do not believe that RAF is an insurer. RAF, as far as I'm concerned, is a social claim. Thank you, Chair.
I'm not seeing the chair. Perhaps I must chair this myself now. You know, I think I'm going to chair this for now, because he refused me to add something, but he allowed my colleague to say something in the middle of something. So I think I'm taking over now officially. Deputy Minister, if you can allow me as well to take over.
That is a decision way up
Or the chair.
You know, Honorable Skosana has been trying to take over since we began. The members know. I apologize, I was too pressed.
Thank you, Chair, because you allowed him. But I'm not going to be petty on that. Perhaps you used your own indulgence of why you allow my colleague and you refuse me at that particular point in time. But thank you, Chair. I think the issue of courts, you know, for me, you know, I was watching the interviews. I'm disappointed, you know, and I know that this is not a point of this discussion, but for us to really depend on courts for our matters, I guess when I look at the board, you know, the credentials, I think the board is capable of taking decision based on our so-called best constitution in the world, and which is debatable. But relying on courts, really, we are going to come back again next year here, because this matter has dragged for long. But I think the Road Accident Fund has all the rights to go to any court. And in fact, I think it is, for me, it's not a complete. When I see this presentation, the legal cost of 10+ million, I've seen that because public funds, we should know even these lawyers, which firms have been paid this amount of money. It's been done before in one of the committees. And I think we need to have that from the CCO, because when it suits them, they want to, I'm not talking about you, I'm talking about some other state institution. They want those names to be published. So I'll ask the CEO to give us those which firm was paid that 10 plus million. And indeed, there's no institution which is alpha and omega, whether AG or Constitutional Court. You know, they might get matters wrong. It's their opinion. And the reconsideration by the CEO, I'll support that. Go to the last line, even if you lose. If you believe that you are correct, we are within the rights, because we are saying Constitution allows you to start from the magistrate court to the highest court in the land. But for us to say ref must be like an insurer, from where I'm sitting, really, and when I look at the ruling of the Constitutional Court, which is their opinion as well, remember, it's opinions. They were correct to say it's a social, it's not an insurer. And those who are exposed, who are traveling all over the world, like my colleague has said here, when you go to Singapore or Malaysia, the first thing you do, you take an insurance. How can we pay, whether legally or illegally, how do we pay for foreigners? And I know from where I'm sitting, I've been, I read all the presentation, and I've been watching the news. I've been watching this matter being ventilated in different platforms. The CEO head is on the line. It's more political, more than anything else. It didn't start with this 7th administration. It started on the 6th administration. When you are a bit hard and you want to do things beyond reproach, I can tell you, they want you out. And if this committee where I'm sitting, we're going to allow that and behave as if nothing is being done behind the scene, we know. We know what is happening behind the scene. The issue of these lawyers as well, like my colleague said, 25%. If a child is on a wheelchair, say I'll just give a number. If there's 10 million rand which is supposed to be paid to somebody who was injured, who won't be able to talk, won't be able to walk in his life again, then the lawyer takes 2.5 million. Is that fair? Why can't I know that there'll be a debate as well. Why can't all the victims be paid directly? Even if there is, but this issue of trust fund, you take money to a trust fund, that's where they manipulate. This money is for poor people. I'll get into the next round. Thank you, Chair.
Thank you, Honorable Skosana. Honorable Esak.
Yeah, thank you, Chairperson. I hear what you say, and I take into cognizance your comments earlier when you were addressing the committee and what my colleague said. But it does remain a huge matter of concern in terms of all this fruitless and wasteful expenditure. I mean, I was going to echo the 10.7 million rand that was a ruling again against the Road Accident Fund on the 19th of April, some 3-4 months ago. So at what point, does one draw the line here and find some consensus in terms of the accounting policies, which has been expended to such a great extent, and the differences that are between what the AG is suggesting, the issue of the IPSAS 42 policy, then the GRAP 3 policy. I mean, somewhere along the line, we got to start being mature about this for the benefit, I think, of the people that we serve as and society and South Africans as a whole. At this point in time, after all these years coming from the 6th Parliament, and the previous chair would know, that surely it's time we need to look beyond all of this and be mature and say, look, what is in the best interest of us as politicians, the directorate of the RAF, in best serving the needs of our people and communities? Because really, Chair, with due respect, we need to, in this 7th administration, but quickly, not in 5 years' time, quickly bring these matters to some concrete resolutions. That's what I wanted to say and suggest for now, Chair. Thank you for the opportunity.
Thank you, Honorable Esa. Honorable Skosana. So just for the RAFT members, we have 2 members of the Skosana family in the committee, so I am not making a mistake. Depending on which one speaks first, that becomes a senior one that day.
No, thank you very much, Chair, and good day to all honorable members, the Honorable Deputy Minister, the Chair of the Board of the RFA, and all the entire team of the Road Accident Fund and all other stakeholders present. Yeah, no, we appreciate the presentation as this committee. At least to hear your side, because I think previously we met with the AGSA on these matters. So I think it is, we appreciate that today we are also hearing your side of the story in relation to all these particular matters. I've heard the chair of the board indicating that you have successfully collected 1.2 billion rands of duplicate payments through your turnaround strategy. I think that is good and commendable. I think we should keep it up in making sure that you try to save the state's funds, the public funds that the state is in charge of, and as a public entity we are also responsible for. I'm agreeing with Mr. Litswalo on the fact that there's a need to change the funding model of the RFA. But I would like to get a comment from the Deputy Minister as to what is your view from the side of the executive. Because obviously, like you was indicating, it may not be sustainable for the RFA to proceed with their responsibilities if we don't have a sustainable funding model, wherein the example that he made that at some point we have to pay somebody a lump sum of 10 million rand on the go, whereas that money you still have to collect it because it depends as to how many claims do you receive. If you can have more claims than the money that you have, it might be a challenge to be able to pay such claims because you might not have funds you are still going to collect. So the issue of the funding model, my view is that it needs to be looked at. So, but I would like to get the comment from the side of the executive in relation to that. Now, with regards to the issue of litigation of the RFA taking AGSA to court, to an extent that you ended up spending 10 million rand plus, and the matter is still ongoing. We don't know how much more are you going to spend on this particular matter. And we hear your arguments on the issue of social benefits versus insurance-like. But my question is, why is this an issue now? Why did this matter become an issue in 2022? What was the practice before? Is it a matter because of the unfavorable audit opinion of 2020, 2021? Or what? Because I hear that you are putting very strong argument, but I'm asking myself as you are arguing to say, but RAF has been there for so many years. Why was this matter not an issue before? Why specifically it becomes an issue only in 2022 when there's this disclaimer audit opinion from the AG? Why was it not an issue before? Or how was this matter handled? The issue of being social benefit versus the issue of being an insurance-like. But connected to that, the issue of subsequent audit opinions, because in 2020, 2021, you got a disclaimer And then 21, 22, you got an adverse. 22, 23, you got an adverse. Meaning the fact that you have been busy in and out of courts trying to settle this matter of 2020, 2021 has had an impact on 2020, 21, 22, and 22, 23. So how do you think are you going to be able to get a favorable audit opinion in the coming year, while at the same time you are still arguing these issues in court? Because obviously it shows that you did not get an opportunity to have an audit action plan and look at all these matters to rectify all the issues that the AG has raised, because you are not agreeing with him or her. So how do you think moving forward are you going to be able to get a favorable audit opinion, while at the same time we are still pursuing this particular matter through our courts? Lastly, Honourable Chair, the matter that I think my two colleagues earlier raised, the issue of lawyers. Well, I will frame my question differently. What is the success rate of individuals who submit claims without the involvement of lawyers? Because I think this thing, it has been made to be like a natural thing that if you have to make a claim, you have to have a lawyer. But I'm asking myself to say, if a person decides to submit a claim without involving the lawyer, what are the chances of such a person succeeding? Is this claiming process so complicated that a layman cannot do on his or on her own? Definitely a person should have a lawyer to submit a claim. Thank you very much, Chair.
Thank you, Honourable Skosana. Honourable Atkinson.
Thanks very much, Chair. And Chair, I'd like to just pose the question. I mean, you very clearly ventilated this whole issue about whether it's a social benefit fund or whether it's an insurance fund. What value are those figures you've given us if you actually haven't followed the correct criteria? So if you've based it on a social benefit fund, what value were those numbers that you gave us today? And then the second point, my colleagues mentioned the court action against the Attorney-General. I'd just like to remind the Minister who the people that joined the case. It was the Auditor-General of South Africa, the Accounting Standards Board, and the Minister of Transport. Now, the matter where they refuse leave of appeal, the court normally does that because they don't believe there's any chance of success in a higher court. And you then went to the Supreme Court and you weren't successful there. So they were actually correct in their assessment of it. So, I mean, obviously now you're trying with the Chief Justice, and we'll see where that goes. But the reality is, until this changes, you actually have a responsibility to follow the Act and to continue to report in the way the Act requires you to, okay? And the question to the Deputy Minister of Transport is, how do you feel about having an entity which is actually not complying with the law? So I know in your introduction you kind of batted it away a little bit, but it's actually a major consideration for the government that you have an entity that has actually failed in their court applications. It may well change. The Chief Justice might decide it changes. But how can you allow a subsidiary or an entity reporting to the Department of Transport to continue in basically in a legal manner? Okay. And then
Sorry, Honourable Atkinson, I just wanted to quick correct. It's the Judge President of the Supreme Court of Appeal. Yeah.
Supreme Court, right, okay. And then I know that one of the representatives of the board was basically saying, you know, it's very difficult because there aren't correct standards in place that one can use to deal with insurance claims. But then why don't you go to the Auditor-General and to Treasury and actually ask them for advice on that matter? It might be up to them rather than up to you as to who that should be done. Now, I know certain members gave their opinion as to whether there should be a social benefit fund or whether an insurance fund. It doesn't matter what we think. It matters what the courts think, and it matters ultimately what Parliament thinks. So we might have opinions, but our opinions, quite frankly, are as valueless as yours are, really, until the Judge President makes a decision and until Parliament makes a decision as well. And then the final point I want to make is just, I believe that part of the board minute is that you don't pay out medical aids, okay? So I've got before me a court judgment here from the 1st of December 2023, Swantonda versus Road Accident Fund. At the very end, the judge says, I was informed during argument that since the dismissal of that application for leave to appeal by the Constitutional Court, the RAF has nonetheless persisted in refusing to pay claimants their past medical expenses. The conduct of the RAF in the litigation before me, at least since 18th of October 2023, when the Constitutional Court gave its order, must be deprecated. It is clutching at straws, and the process depriving deserving claimants of their lawful entitlement in the process is shamefully wasting yet more public funds, which should be directed at settlements of worthy claims. I really would like your comment on that. Thank you.
Thank you. Honorable Madlala.
Thank you, Honorable Chair, and greetings to honorable members, the Deputy Minister and the delegation. Well, the first part would be to at least express myself in the following manner. There are quite a number of issues that and complaints we have received, that I have personally received about the Road Accident Fund, which I would have hoped to go into, ranging from the understaffing, the backlog on cases leading to litigations, the acting positions allegedly which are in the department, the possibility of shutting down certain branches like the Durban branch and all of that. Contract positions which are not fulfilled over a period of years. But I see that the gist of it all today rests around the issue of the identification of RAF as whether a social grant or an insurer. And maybe I want to say, sometimes because of how vested we are in these institutions and the goodness that we desire for this country and for them to succeed, we may fall into a trap of getting so attached to our views that we want to go and pursue them till the end. But from where we come from, we normally say you comply and you complain later, you know? It does not deprive the right to pursue what you believe is correct, but in the meantime, we need these institutions to be compliant, to be operational, to service the people, which is the part of the most important things that it needs to do. And the two that do not contradict with each other. When we looking at the findings for the past years, they are not looking good. The Auditor-General, in their view on how this should be approached, I believe that also have the responsibility to provide the necessary guidance. We've been informed that there have been some changes and new introductions of certain standards and all of that. So in their view, they should also be able to provide how can then compliance be ensured within the standards that are set, whilst the process may continue. But also disappointingly, this expresses the failure of government to mediate, such to an extent that the courts then must make determinations. Because this is one government, and there are experts within the same government. I don't know to what extent, even though the courts may apply their legislative mandate, but the departments that are involved should be able to sit around the table and come to a logical conclusion about the matters. I wouldn't want to venture into other possible, political issues around the matter. But at the very least, these are not our institutions. If you are appointed as a CEO or a chair of the board or a minister or even any committee, we don't own these institutions. We did not develop them. We did not start them. These are institutions of the people. And the people are bearing the biggest blunt at the ground when things are not happening properly, because we amongst ourselves have different opinions on matters, fighting our own egos or our own political issues. By the way, people are not even interested in that. They want to see their payments when they make a claim. And I think that should be the priority and the driving force of our own imagination in terms of how this institution should be functional. Like I said in the beginning, there's quite a list of issues, a lot of issues. Well, if you can go out today and check the public perception also, you know, and I'm not saying that the public perception is the central point, but I'm saying these are public institutions. How the public view them and the public confidence in them is also very important, because it's theirs at the end of the day. In fact, if there were to be a vote and they say close them, ideally in a true participatory democracy, we should have to close them. They are the final arbiters, and then they express that through the vote and through the representations and so forth. So I think that we should, my own view on the matter is that let's find ways in which we can comply. Let government come in an integrated, interdepartmental approach to come in and mediate the situation, find an interim measure, and allow that if needs be, the other processes are ventilated, but in the meantime, there must be compliance. Sitting here as a member of SCOPA, what I would desire is to see an improvement in the audit outcomes, the financials coming right, the delivery to the people coming correct, and the other technical issues could be dealt with. They could be resolved in 10 years, 15 years, and so forth. It's the list of my concern. But in the main, we want to see the people getting the service that they have mandated this institution for. Thank you.
Thank you, Honorable Madlala. Honorable Maduna, welcome back.
No, thanks, Chair. I will be very short. As my height. No, Chair. I think one should begin by checking, in line with what my colleague Honorable Madlala would have spoken about. Perhaps, Chair, through you, one would want to check with RAF that besides the issue of this, the issue of how you recognize your liabilities, of which is the issue that we are currently mostly on discussion on. If that were to be sorted today, would the audit opinion of the entity improve drastically? What I'm asking basically, Chair, is that the only problem at RAF in terms of their AFF, that your AFS that lead you to be where you are? I think that's one, Chair. Two, Chair, I think perhaps, I think I would have said this in transport as well. We need to, as well, on our side, try and support RAF. Maybe, perhaps, look at the amendments that are required. I know there's an amendments that they would have wanted that would have been made, because I do not believe there are many elements that are wrong in the current RAF Act. For instance, you can't, when you put a claim that is missing key documents for you to be paid, but after 60 days, if they did not reply to it, suddenly it's a valid claim. That's pure nonsense. I don't understand who was preparing that act and why would they would have prepared it in that manner. Two, you can't
careful, that member may be here.
Okay, but Chair, really, I don't get it. I really don't get it. Chair, I think there are things like illegal foreign nationals. I don't get it, and I'm surprised. I was watching one case where I think they were delivering a judgment or something where they were speaking about illegal foreigners that they must also be covered by RAF. I don't know. People might be in South Africa illegally, but I don't know. But there was a long story around that RAF must also, they may be as well be eligible to make claims to RAF. And usually, when we speak about illegal foreign nationals, it always appears if we refer to our African brothers, but they are not the only illegal foreign nationals that we have in South Africa. There are many white people here who are illegal foreign nationals and many other races, and we need to be bold on that. When we speak about them, it must be clear that we are speaking about all illegal foreign nationals. We are not only speaking about our African brothers. That we must put into perspective. I think as well, it would be, we must exclude all foreign nationals actually, whether you are here legally or not illegal, we must exclude all of those people who they must not be paid for by RAF. And as well, I would have always made this. You see, Chair, for any fund to work, you need to have a criteria in terms of if you lose your nose, how much do we pay you? If you lose your ear, How much do we pay you? We must not pay you according to how much do you make you as a person, but we must have a particular established criteria that this is the established norms in terms of how we make payments. So I'm saying, I'm just throwing that so that as Parliament, when we do our work, and obviously it must be started also through the ministry, we ensure this is one thing that we need to look into, and we must look into very, very, very urgently. And also on the issue of medical aids, actually I want to applaud RAF on this one. You see, Chair, as an individual, ne, you pay a medical aid to take care of your medical expenses. Now, I don't get it why when you get into an accident, all of a sudden, they want those medical expenses to be paid by RAF. Because you are contributing from your own pocket, taking care of yourself, ensuring, envisaging that in future, if you were to face anything that requires medical expenses, it would be taken care of by this particular contribution that would have been making. So I want to applaud them on that. Actually, it's a fight that they must continue to fight, it regardless of the court. Actually, that's one thing that they must take to court. That one. Chair, as I land. I think, Chair, I just wonder, I had few questions on the slides. I saw that you have a loss on disposal of assets and liabilities. I just wanted to check what are those, perhaps just in detail, not in detail, but a high overview. I'm not sure which slides, but I think it should be the financial position or the performance, yes. And as well as finance cost, perhaps just a bit, because I want to understand what are the finance costs that you might be incurring. As well as, I saw that you were perhaps just a further more clarification. I saw that there is an increase in your provisions. Obviously, that would mean that you expect more claims, but I would have saw that there are decrease in terms of the payments that you would have, the claims that you've already paid. So just the basis of your assumption. And lastly, Chair, I think you say, Chair, in some, well, not only us, but in any accounting environment, before you change an accounting policy, there are particular and established practice guidelines, obviously framework and other applicable standards and acts. Ne? And I've been saying this with RAF, I think there's something that we are not getting here. Now that I hear that there were some letters and so on, I think there's a particular change process that they would have taken, obviously, before they change the accounting policy. And Chair, through you, I would love, can RAF take us through that process that they would have taken? Because I believe that in that process, it was required that AG participate, obviously, the board, the standards board participate, so that we do not find ourselves in the situation where we are at today. So I think if it would be very helpful if perhaps, Chair, they may quickly just take us through that process so that we establish where we missed or we lacked or where there must be any confusion, where we ended up being in the situation that we are. Lastly, SCM staff, Chair, they must be included in the lifestyle audit. You see the problem in South Africa, the biggest problem in South Africa that we have. Public has the assumption that politicians are corrupt. But in reality of the matter, politicians are being corrupted by officials. Who are those officials? Majority of those officials are officials who works for SCM. Because when politician arrives there, me and you know, politicians do not sit in bid adjudication committees. They do not direct who gets a tender, but it's officials who goes to them. Hey, Mtomkhulu, what do you want? Brief me so that at least we channel your things correctly. Now, those are the people, they are living in lavish lifestyle. Those are the people that we must do lifestyle audit on. I thank you, Chair.
You know, I'm worried if somebody says Mtomkhulu to you, Honorable Matuna.
No, thank you, Chair. You know, there's something I wanted to start with, Chair, and unfortunately, Honorable Atkinson has stepped out. Because as a committee, as a new administration, we are on a fact-finding mission, Chair. And this is why RAF is here. Because AG came to us, he gave us a report. We viewed it as a damning report. we saw RAF as an entity that was collapsing. But there's a different picture I'm getting from RAF. And I don't think as a committee you have taken a position. And I'm still going to lobby you, Chair, to say maybe we might need to have our own strat session to then establish what position we should take as a portfolio committee. Now, for Honorable Atkinson to give us an attitude to even say that our opinions don't matter, RAF must comply and they must do the right thing, it's not going to assist us, because this problem has been lasting for 3 years simply because of such an attitude. And now I'm getting that there are outside forces here, Chair, that are at play with this thing of RAF.
Sorry, so Honorable, let me just deal with my understanding of what Honorable Atkinson was saying. So can you switch off your mic? I'm just going to offer my understanding. So what I understood him to be saying was not that we cannot express an opinion. In the context of what he was saying is that until the law changes, all of us must comply. We may have different opinions about whether it is right or wrong. As long as the law remains the same, those opinions don't matter until it changes. So that's how I understood him to be saying, and not saying the opinion of Parliament has no force or effect. In fact, my expectation is if there is something in the legislation that we do not like, it actually is our job, not the board, to change the law. That's expressing an opinion, but I did not understand him to be contradicting that. I understood him to be saying the law currently is what it is, follow it until it changes. That's how I understood it.
No, that's fine, Chair. I just needed to pass on that. And maybe also as a getaway on that point, I'd really like the Deputy Minister to comment on the legislative reforms of RAF in terms of how far those processes are. Is it something that they have an appetite to look into? Because I do believe that RAF as a scheme, besides their funding model not being sustainable, but also the people who seeks to benefit at RAF are a problem. The scheme is not tailor-made for our people. And this is what was being advocated now by Honorable Maduna, to say that even those who afford medical aid and everything else, the rich of the richest, they still come and claim a draft. You know, so the entire scheme is structured incorrectly, and it needs huge legislative reforms. And that's not part of us as SCOPA per se, but the Portfolio Committee of Transport must then expedite those things. So I'd like the Deputy Minister to speak into that, so that we are able to see. And again, Chair, as a last parting shot on this one as well. That's why there is no huge backlash regarding foreigners benefiting from this scheme. Because I don't have this report, but if you were to get the reports of the largest foreigners or the largest beneficiaries of foreigners who are benefiting from RAF, you'll find that their color is white. But if they were black, you'd be hearing that, hey, South Africa is collapsing here and foreigners are benefiting what. So maybe RAF should give us that report that of the 1.5 billion that is owed to foreigners, they must give us this report that who are those people. You are going to see. And then you'll realize why then there's no outcry that foreigners are benefiting from RAF. But a foreigner comes to South Africa and opens a salon to cut hair, then there's a problem, they're taking jobs. But it's just a passing shot. So let me just get on to that. You see, I'm getting a report here. About Webner, Brownman, Guilford, Norton Rose. We must get this comprehensive report so that it will assist us to formulate a correct position on this issue. So, Chair, when the CEO speaks, I want him to give us the value of the correct classification and what benefit does this give RAF in terms of the recognition of liability. So if they are correctly classified as a social benefit, what value does that give them in terms of their liability, and what impact will that have in their financial statements and everything else? And I don't know, Chair, honestly. I heard someone saying that in terms of the audit outcomes of RAF, everything is unstable. But you know, if you look at this audit report, if you look at their projects and their procurement and contract management, they're on the green. Their expenditure management, they're on the green. Asset management, well, at least for 2023-24. Consequence management, they're on the green. Strategic planning and perform, they're on the green. So really you can see that the perception that is out there about RAF collapsing is really a perception, and there's an explanation for it, and that's why they're in court. So we ought to get to the bottom of the thing and really understand what is going on here, so that we really formulate a correct view. And I would like the AG to come in as well. I don't think, or I've not heard, that the AG is disputing that RAF is a social benefit scheme. I understand that the AG is saying that they do not enter in setting a standard. So they found a standard, they are auditing RAF in that standard, and this is their finding. But whether RAF is a social benefit or insurance, I don't get the sense that the AG is disputing that. And the CEO is also saying maybe when the DM is speaking again, he might even need to come on this one to say, where is it in legislation where it's stipulated that RAF is an insurer? Maybe let's get that. Maybe let's not ask the question that where is it stipulated that they are a social benefit. Maybe let's ask where is it stipulated that RAF is an insurer. And if RAF is indeed a social benefit, but I mean, it was the chairman, it was the chairperson, my apologies. It was the chairperson who was saying that one of the three entities as well that are an insurer in the country is UIF and the others. Their accounting standard is different from RAF. So why is that abnormality there? Why does it exist? You know, so all of these things are really concerning for me as a person, and I hope that I'm advocating this chair to say that when we are sitting as a committee in our own strategic planning and we want to develop a view on RAF, we must be able to ventilate these things and come out with a clear perspective. Maybe as a parting shot, Chair, I would also like us, maybe through you, Chair, in writing, let's write to National Treasury for them to give us an explanation, and the Accounting Standard Board, for them to tell us that did RAF ever engage them and follow a particular process to change an accounting standard, so that we have the information? Because when you spoke to the chairperson, she gave us an opinion a suggestion that at some point National Treasury agreed with them. At some point the ASP agreed with them, but it changed. So we might need to go to them so that they give us those details to say, okay, at the beginning you agreed with the RAF, they changed. And then when they changed, then you change. Then that's where the dispute might be. So we might need that. We've heard from the AG, we've heard from RAF. Let's hear from them. And then when we sit, I think we are going to be able to come up with the clear program going forward. Thank you very much, Chairperson.
Thank you very much, Honorable Blosse. So I mean, you are correct in several respects. So one of the reasons I had asked the Road Accident Fund to just speak to this change in policy was so that we kind of we complete the cycle, at least between the two institutions. And I think it's a valuable exercise in future to kind of take ourselves to a point where we're able to form a view, right? At least in terms of how we conduct oversight over the period. Just to reiterate, Honorable Blosse, what I said earlier on, and the committee will have, so I'm meeting the staff after this, and then we'll have a session. The idea is that we have a template of a accountability between ourselves and all the institutions. The RAF would be one of those. The information that gets provided reflects our view of the institution in terms of its importance and its issues and that kind of thing, and that it is predictable, and we meet on a regular basis and we deal with these matters. So as far as that is concerned, we are going to get there. So we've got until 2 o'clock. We don't have to go until 2 o'clock. today. So I'm going to try and get us to a point where we finish here at lunchtime, and then we can all be released. I'm going to ask a question because I recognize we started at 9. It's now 2.5 hours later. The Deputy Minister and the RAF team have not had time to go on a body break or something. I'm going to ask you and the honorable members a question. Would you rather take a break now? Let's say the time is 11:32. Let's reconvene at 11:45. Take a break. We come back, deal with the questions, clean up any outstanding issues. We talk about the way forward, and then we are out of here. Would that be acceptable? Thank you. Let's come back at 11:45. Now I know why there's a bell here in Parliament. You know, the members stay out. Yes, yes. Welcome back, honorable members, honorable deputy minister, chair. Sorry, I nearly said honorable chair of RAF. Not that you are dishonorable, but the titles here working. So, chair of the board and chief executive and your respective teams. So thank you very much. Oh, those members. You know, I'm going to become a school principal and separate them. Yeah. I need to separate them and have Honorable Matuna here next to me. Yeah, next to me. Yeah, I can see there's a situation going on. So thank you very much, members, and I can feel the energy in the room has lifted a bit. So I'm just going to clarify something. So when we had the Auditor General here, and I want to give the Road Accident Fund team this assurance. When we had the Auditor General here, what Honorable Blose was referring to, it actually was not these audit outcomes. We have not had the benefit of a presentation on these audit outcomes. What we were doing is what he was referring to earlier, the fact finding, just call it an extended induction to understand the historical issues and so on. And that is why in my opening and the way I asked the question, I said we have not taken a view. We're still going to have an accountability framework for ourselves, and it's fair and open. It's predictable. So we are still going to get the benefit of a presentation by the Auditor General on your audit outcomes. We are going to take that into consideration when we work with you. So again, we'll work with the ministry. We will work with you, chair of the board, so that the frames of that accountability are mutually agreed between us, and we can publish them and people know with the things that we talk about. So it's going to be a transparent process that gives the necessary predictability. So what I'm going to do is I'm going to give you, Minister, and the board chair, because some questions were for you, Honorable Deputy Minister, the board chair and the chief executive and anyone you nominate from your team to deal with the various matters to do so. I will then ask my own questions, which are really premised on the presentation itself, because I always try and give the members the first opportunity to make the substantive questions after clarity seeking. We do just one last round of further clarity, and then we hopefully close and we leave. So thank you. Over to you, Honorable Deputy Minister.
Thank you, Chairperson. May I request that the Chair responds and the CEO, and then I will deal with the questions which were directed to myself.
Okay, that's fine.
Thank you very much once more, Chairperson and honorable members, for all the questions and comments. I'm sorry, I'm going to deal with high-level matters, and then the CEO will deal with the specifics. Chair, I think it's very important to understand that the board's position has always been to try and find an amicable solution. Like I said earlier on, it's a technical matter that requires a technical solution. And currently we are in a stage where we have to start preparing for the next financial year end. So getting support from all the role players, especially being guided by our parliamentary committees to bring all the role players together, I think that will assist us in finding a temporary solution so that the Road Accident Fund can find an interim solution while the standard setting body is finalizing the standard. And I think by way of information, they've actually issued an exposure draft early last year on a social benefit standard, confirming that there is a vacuum in that space. So if that can be finalized and fast-tracked, then we will basically have a long-term solution. But in the interim, we really need the role players to come back and agree on the way forward, because there is a vacuum currently. So that we will truly appreciate. And there was a question around where, in terms of our audit outcome, if this matter is resolved, what would be the audit outcomes? When we came here in 2019, RAF used to get clean audits. And if you read that audit report very clearly, everything is green other than the financial statement. And on the financial statement is this issue of the liability. And under compliance, the only thing that is orange, it's that aspect relating to the accounting of the liability. So if that matter comes out, RAF would go back to a clean audit status. I mean, the auditors have never said that there's mismanagement at RAF. The way, even the operating model, the changes. If you look at the management report says that there's a lot of positive aspects in the improvement of the control environment and the fact that we were able to stabilize the organization. So there's positive aspects coming out of that audit, but unfortunately the focus is on the two elements that have led to a disclaimer. So we are really, as a board, would like to have a technical solution so we can move on and focus on the claimants, because we want the claimants to get the most out of this organization going forward. And lastly, Chair, I'd like to say the regulatory transformation we really needed. The RAF amendment bill, we've submitted it early last year as well. So if you can fast track that process, because it deals with all the issues where, in terms of sustaining the organization going forward. I think one of the solutions that we've raised was that paying in installments, our long-term liability in installments, will free up the finances for the organization so that this organization doesn't become a burden to the fiscus. Because if we do that, then we will be able to match the asset and the liability in that we receive our levy in installments and then we'll be paying our liability installments. So that is already in the bill. And also issues of dealing with foreigners is also in the amendment bill. And so there's a lot of, and the direct claimants as well is also in the new bill. So this bill will ensure the long-term sustainability of this fund, but above all, ensure that our claimants, become the co-focus going forward. So we are really happy that we need to find long-term solutions to this problem. Thank you, Chair. So I will allow the CEO to deal with the specifics. Thank you.
Thank you, Chair. Over to you, Mr. Lutswalo.
Thank you very much, Chair. I think, Chair, I'm going to try to capture what we have done to the change until the change in accounting policy, because it becomes important. It answers a lot of other problems, and I think there are other issues and the challenges that we have. But I think also what used to happen before we change the accounting policy, that becomes very important. And that will help us address a couple of things. Then I'll try to deal with the specifics, as it were. We arrive in 2019, this fund is collapsing with a clean audit. It's collapsing, it has a clean audit. But what is strange is the nature of the collapse not defined. About 43 billion gets collected. Someone says, go check this. I'm the CFO of the Department of Transport at the time. So I'm asked to go and look at this issue and see whether the RAF can be actually saved. One of the things that was said was that the 6th administration wanted to know if there is a need to close it, because it was also a fiscal risk. It was said to be the second biggest liability after ESCOM. That's how it was defined, Chair. And I want us to disabuse ourselves of the idea that there was this healthy organization that was working and working well. At the time, Chair, there was a thing called Road Accident Benefit Scheme. The Road Accident Benefit Scheme, the bill was sitting in front of the Transport Portfolio Committee to try and change, give legislative changes to what was an unsustainable fund. This unsustainable fund, Chair, starts in 1942. It has been bankrupt since 1981. So the idea, and I want you to see it in that context, Chair, because it becomes very important to understand the notion of the road accident fund. So in 46, it opens its doors. It is based on on common law principles of damages, and it is delictual in its outlook. So you are suing someone. So people were suing drivers, and drivers were having difficulties in paying. It started there, Chair, but what they did, they actually fixed the amount you were supposed to pay. The state said, you are going to the private sector, you will provide this cover, this is how much you must charge. Continuously, then it has got a different kind of commissions of inquiry as it goes. Then somewhere in 1986, it collapses altogether. So for about 4 or 5 months, South Africa never had this insurance, because people used to buy stickers, Chair, of what is called third-party sticker. You put it on the thing, but you bought it for insurance companies. It collapsed. Then the state decided to collect this money through fuel levy. And that's when this thing transits to be from insurance to social benefit. The idea then was that these insurers will continue to administrate it, whereas the state will collect the money, the administrators will keep on being these insurers. It continued, Chair, until 1996 when the RAF Act is passed. Then all those people that were insurers were then moved into a RAF, and then RAF becomes a state entity, a social benefit scheme as it were. Now, we then, just before that, in 92, there was a Melamed Commission. Own resolutions, what must happen. Then in 2000, I think in 2000, they started this, there was another commission of inquiry headed by Judge Kathy Satchwell. The Satchwell Commission released its report in 2002. That report talked about RAF as a social benefit and what it must do and all those things. And some of these things were then effected through a legislative change of the amendment in 2008. In fact, what we then pick up, Chair, is that the amendments of 2008, instead of aiding the RAF, created more problems. But they were short-term in nature, because there was a RAPS bill that was going to really repeal the RAF Act, as it were. But one thing that you find every time since 1942 is that this scheme is not sustainable. It kept the features of damages, meaning, Chair, you must prove your damages. It kept the features of delict, meaning you must sue someone to get those damages. At the time, since 2000 until 2008, public passengers in general, I think, had a limit of about 25,000. It's only removed in 2008. Now, we sit with this thing It's sinking. It has been sinking ever since. The state has just been trying to prop it up. But what is important is also what Judge Bertelsmann calls an inheritors damnosa, that anyone who inherits this thing is bound to fail anyway. Then we look at what the issues are. The minister says, look at this thing, this liability, assess it. We come in, Chair, we assess this liability. We then pick up that somewhere in 2014, this liability started to grow exponentially. The liability, Chair, at that time was sitting at 320 billion, actuarial liability. We look at this and we say, but what fundamentally happened in 2014? We look at the accident rates, they have not increased. We look at the number of claims, they have not increased. We realize one thing, there was a change in accounting policy. We go back to the management reports, we pick up that at the time, the RAF had a provision.
Sorry, Mr. Lutswalo,
Yes.
can I ask that you do the following?
Yeah.
Because we started at 19, was it 42?
Yeah.
Okay. So can we take some things as accepted fact, right? One of those is that, can you just switch off your mic so that we can get to the members' questions? One of those, I think there is no disagreement that there is a funding problem, one. Secondly, there is a problem with how the road accident fund is kept liquid, and the impact of legislation and so on in producing that outcome, right? I think anybody who looks at this rationally would know that. Let's start here. As a result of legislative and previous decisions and so on, the road accident fund has always been hopelessly insolvent, like hopelessly. That we know. It's not just underwater, it's deep in there. This is fact. And I don't think for the purposes of answering the members' questions, it's important at this stage to litigate the matters. What is at stake, right? And we ventilated it before, so I wouldn't like us to kind of repeat our own conversation, is really that there is an adverse AG's opinion on the road accident fund. It appears to be the main sticking point between the two institutions. There is litigation now. We accept, and I think anyone who looks at previous annual reports will see that a problem. So can you please start it? This institution is hopelessly insolvent. We accept that, right? The numbers are the numbers. And this is the problem we try to solve. And therefore, this is how it informs what we're presenting to you today. I think that will help us also with that objective of not being here all afternoon.
No, thanks, Chair. All I just wanted to do is just paint a picture so that we arrive at a point where all of us are in line, and I'm happy that we are now aligned. Now, this accounting change in 2014 created a distortion. It took that what became a contingent liability and it called it a liability. Because the AG at the time, notwithstanding the fact that we are not an insurer set to use accounting for insurance contracts. But their view was that we are saying that because there is a letter coming from the ASB saying everyone must now use IFRS 4. And they say this is an instruction. This is an engagement we are having with the AG at the time. We engage with the AG. It is 1920. They say we are too late in the process. Let's engage next year. We engage next year. We are looking at this accounting. There is a problem here. What do we do? They say go to the ASB. We did, Chair. We went to the ASB. We said next year, which is 2020, 2021, we'll go to the ASB. We went to the ASB. This, Chair, is very clear in the response that we had. I think it was on the 22nd of January that we met with them. The response came from on the 1st of February 2021. In the response, they say, no, it's not true that our letters were giving you that you must use IFRIS. We said consider using it, but it's up to management what they want to use. We have never instructed you. In any event, I think it was Ms. Swart at the time who said, in any event, how the change in accounting policies defined very clear in GRAP 3. I think it is paragraph 13 or something like that. It is here. Our letters are not authoritative, and therefore it's up to management. Then we proceed, Chair. We proceed, we change this thing in line with what they tell us. We explained to them, they said, this is what you must do, apply yourself, do this, do this. We follow that whole process of the ASB. The AG is attending all the meetings, at least our own audit committee meetings, where they know we are busy with this process of change. Then we finish that whole process, Chair. The board then changes the accounting policy. They then say to us, no, but management, we see what you are saying, but go out and get us an independent view. We go to one of the biggest accounting firms. I think there's the one that won the award, is PwC. We say PwC review the process. If you look at the letter of PwC, it's a review of this whole process. Did we follow the right channels? Did we get the right approvals and everything? The PwC comes and says, all good. What you have done is fine, we agree. They then advise on certain disclosures and how we must change those disclosures to say you might be wrong here, just change the disclosure, but in general, the change is fine. We then change the accounting policy. We then come, we present financials. It is at that point when we are told, no, this might be inappropriate. We didn't understand what that means. Then they said, let's go and check. We will look at that during the audit process. We submit financials, that happens. We then follow up, Chair. They then issue out a finding. We again go to the, on the 5th of August, we then go to the ASB. We write a letter. It's called Request for Guidance on Change in Accounting Policy. That's the title of our letter to them. They respond to us on the 23rd of August 2021, Chair. In there, the response to request for guidance on change in accounting policy. It's there, it's the 23rd of August. But they say the following, which is very difficult when you sit with us now, having to do. The ASB is not, a part of what they say is the ASB is not in terms of its mandate. It's not permitted in terms of its mandate to provide technical opinions as providing accounting advice on individual transaction would conflict with the role as a standard setter. They then say, based on correspondence provided, we have several issues which we believe may be relevant to resolving whether the changes made by the rough accounting policies are appropriate. It's them saying that, Chair. In the very same correspondence, they get to a point where they say insurance versus social benefits versus other benefits. The interesting thing is the key considerations. They say the key consideration in deciding whether the principles in the pronouncements of other standard setters could be considered in formulating an accounting policy for a transaction, circumstance, or event is to understand whether the underlying transactions, circumstances, or events are the same. Then they say IPSAS 42 defines social benefits as follows, and they give us...
Mr. Letsalo, can I stop you?
Yeah.
This is not going to help the proceedings. I'll tell you why.
Yeah.
We are redoing the court case here. We are redoing the court case here, and this is inappropriate. we've accepted that the matter is under litigation. We need to get to the questions. If we listen to this history and you telling us, and I've had the opportunity to read all your court papers by all of you and the AG, we will be here until 3 o'clock, say. I'm not trying to cut you off. The members have asked questions, please deal with those questions. This matter is obviously really important to you. It's close to your heart, I can see. But it can't be the only thing we deal with here. Please, Mr. Letswalo, we've accepted, I took you through that process earlier on so that we avoid this, what we're doing now. The facts have now been established at a high level, right? The matter is under litigation, and the judge president of the Supreme Court of Appeal will pronounce. Because ultimately, notwithstanding what you are telling us, the courts have so far found against the Road Accident Fund. We are not the judiciary here. The arbiter of legal disputes in South Africa is the South African judiciary. We are not going to litigate the matter here, Mr. Letswalo. Please, can we go straight to the members' questions? Please, I'm not cutting you off. And I've said this is not a spurious matter for me. So I don't regard it as a nothing issue, okay? It's really important. The reason I'm not expressing an opinion is I'm waiting for the courts to make a determination. And I think all the members should do so. The judiciary, no, I will give the members an opportunity later on to ask follow-up questions. The judiciary here in South Africa is a final arbiter of these matters. You've taken the matter to court. None of us here have said you're not legally permitted to do so. I haven't said so. Let's let the court processes finish now. Please don't relitigate the matter here. Can we deal specifically with the members' questions?
Chair, I thought I was, but I'll tell you why. I was answering the part that says take us through the process of how we arrived here, but that's fine.
Can I make a ruling then? And it was Honorable Blosse. I will create an opportunity for that to happen, but I want to be clear. I want to be clear, members. We are not the courts. We are not going to make a finding that says, that contradicts what the courts are going to say. The matter is being litigated. We either respect the judiciary or we do not. The matter is in court. Well, it's not technically in court right now, but the matter is in court. We are going to wait for that finding. Whatever the courts say, Parliament is obliged in terms of this constitution to go with it. That's how our law works. We're not going to create an alternate framework, and therefore, Mr. Letswalo, it's not necessary for you to relitigate the matter here. I took you through those questions in the beginning so that we get clarity in what the nature of the dispute is. And I think that suffices for the purpose of this meeting.
No, Chair, noted. The honorable member asked about finding a mechanism of helping the poor and the exploitative behavior from the unscrupulous lawyers. Look, I think, how do we help the poor? Not with this law, Chair. Section 19C of this law says you must use a lawyer. Is this cumbersome? Of course it is. I mean, how do you sue someone without having a lawyer? Why would you even have a situation where there's a social benefit that needs a lawyer for you to access it? So it's not for the poor, this thing. And that's a fact. As I said, it's the most regressive form of taxation of benefits I've ever seen. Because the ones that have the most will obviously get the most from the system. That's how it works. It's worse that even your own child, how they assess whether your child was going to have potential is on the basis of what you have. So if you are like me and your mother was a home executive that never had an income, chances of you giving income, they take the trajectory of your father. But we know why, because it's a 1942 issue, right? So Are you going to get lawyers out? No. There is a reason why this thing collapsed, Chair. That's why the RAPS bill collapsed. The legal fraternity is a very convincing and strong lobby group. They've made sure that RAPS never sees the day, and they pride themselves with that, and they will do that. The foreigners, Chair, and this is the part where people say, well, RAF likes going to court. There's no truth to that. It's one of the cases that we are taken to court for refusing illegal foreigners to benefit from the scheme. Because it's our opinion, Chair. It's something that we are also appealing. Lucky enough, now we have got our leave to appeal, where we were told that foreigners can be here illegally but constitutionally. So we didn't know what that meant, but that was the outcome. You see, why is the law not preventing foreigners from claiming? Well, we don't know, Chair. It's the law, we are implementing the law. The biggest beneficiary we have in this country, it's a Swiss national who has paid more than 500 million of money. It's worse. When you go to other countries, you are not even allowed to claim a social benefit. And you must tell them, I'm not gonna, let alone the fact that they will say, please get insurance for yourself. But they say, also sign that you will never ask for social benefits in this country. They do it. The UK is the first one. I've just applied for their visa, and that's what they said to me. So that's what happens. We always comply, and Chair, when we started this and then we said we don't need lawyers, people said, well, this thing is not gonna work. We are saying this, Chair, we have saved this entity 24 billion in legal fees that we have taken and given to beneficiaries in the last 4 years. It's about 6 billion a year that we have saved in legal costs. Was it an easy feat? It was not, Chair. It was never gonna be easy. The 10.7 million, Chair, that we have, we do not think is fruitless expenditure because there must be clarity. We are spending 10.7 million to avoid accounting wrongly for 315 billion at least. So it's not necessarily cutting our nose to spite the face, but 320 billion of a liability that we are supposed to account for, which is not there in our view, can't be fruitless and wasteful expenditure. It's not in vain, Chair. It will create clarity about who we are and how we must account. I think that's the issue. The funding model, it's unsustainable, we have agreed. What was the issue? I think I've explained this one, Mr. Skosana, on how we used to account before 2019. What would the opinion look like? I think the Chair has already clarified that. It will be a clean audit, because that's the only thing that is between us and that clean audit. What is the success rate of individuals that don't use lawyers? Well, we'll never know, because in any event, what happened is that our predecessors tried to do this thing of driving what was called direct claims. They've got a particular problem. If RAF does not respond in 120 days, you must issue summons. I can issue summons myself. I, Collins Litsolo, can issue summons myself. So you need a lawyer. So it's taking you back to the lawyer. In fact, to the extent that Section 19D says if you enter into a contract with any other person than the lawyer, the RAF must not honor your claim. So you can go and read Section 19D as it were. It's shocking. What is also shocking, of course, Chair, is Section 18.4 that says to our people, go and bury these people before you come to claim from RAF. If a family has lost, like we had a family that lost 5 people at the same time, they are expected, notwithstanding them being passengers, to bury their own, and all they can claim is the cost of entering someone into a grave. We know our people. You must buy a cow or what. We don't cover those. That's this act as it sits today. Mr. Atkinson says, what value are those numbers? They are as valid as the AG says they are. There's only one number we don't agree on, is the liability. They don't say to you that our RNYP is wrong or anything like that. They've never said that. And that's why we say, when they give us the action plan, we implement it, Chair, on every other aspect, which is why you would see that we have added another one, which is systems, and in there is also green. Because we take the AG seriously. There's no point at which we don't. We just disagree with the AG. That does not mean we don't account, Chair. We do account. A disagreement and in one aspect cannot then make the AG and the auditing a futile exercise. It is not. They are an important element of what we do as we account with public monies. We are reporting in line with the law, Chair. Grab 3 says that the management shall develop an accounting policy where there exists no standard of grab for that particular transaction. There exists no standard of grab for that particular transaction, Chair. We have developed an accounting policy. And I've already said how we have gone about developing that accounting policy. Medical aids. So, prescribed minimum benefits are exactly that, Chair. They are in the realm of medical aids. Nowhere in the RAF Act are you going to find where they say the medical aid must claim. You know what medical aids were doing? They would hire a lawyer for their members to come and claim from RAF. Why would they go about doing it in such a way, Chair, where they hire a lawyer for lawyer to claim? And when the lawyer claims, he doesn't say medical aid, he says, I'm claiming on behalf of Collins. And then after that, the money must be paid to them. Section 19D says you can't enter an agreement with anyone who's not listed in 19C. The medical aid is not listed in 19C, so they can't enter into an agreement that once the money is received, it must be paid to them. It's unlawful. What have we done? We have taken it to court. Of course, the view will be, well, the court disagrees. Yeah, we have appealed because we believe very strongly that the Medical Schemes Act is very clear about whose role it is. By the way, medical aid schemes are not insurers. They are also social benefit schemes. So our view is that we are opening a litany of other things in our view that would not help society, but also would not help this country. Where we are saying people must now go and claim from SASSA. I must join and say, this is my retirement fund, and then it must now go and claim such as the portion I was supposed to if I was not part of that. I don't think that's what we want to do. And Chair, we are in battle with that one, and it's in line with the law, as it were. So the prescribed minimum benefits, Chair, other things that are not prescribed minimum benefits in terms of medical aid, we pay. So they must not create an impression that we are not paying everything. Honorable Madlala says that there are internal matters. And it will be remiss of us to come in here and say, well, the RAF is operating like no, it's a process, Chair. It's a process. Consequence management, all those things and all that. we get a green because just a few days ago, one of our own employees was sentenced to 12 years in prison. That's our work, okay? So we are not gonna be liked, Chair. It's understandable. But people must not distort what we are doing. The kind of work that we have done will show you. We'll show you, and it's audited. The another things about it is that it's audited. When they come in, they say 91% is audited. We do our work, Chair, as it were. Are there issues? Of course there are issues. Are people feeling overworked? All of us will claim to be overworked at some point or another. Are we doing something about it? We keep on. This thing of saying Durban is going to close is not true. In fact, we are opening other customer experience centers in KZN. That's a fact. The difficulty with it is that also these areas where our offices are, it's not in areas where most of our people live. It's not rural. It's not. You will never find us in a township. We are even reigniting the part where we are in hospitals because we want to be there where our people are so that we can assist them. And that's the reality. We are not in the business of fighting with Chapter 9 institutions, but we are in a business of disagreeing with them where we think that they are wrong. We don't believe that they are always right, much as we are always not right. But it's something that the perception that we just disagree with the AG or everyone for the sake of it can't be true, Chair. The reality is this: if you check all the litigations that we've been in most instances we are respondents. We are respondents. We are never the ones that start the litigation. It's very rare, in rare cases, that happens. Our people must complain. They are allowed to, which is why we opened the call center. We never had a call center. We have a call center now. We have taken 288,000 queries, and we have resolved at least 96% of those within the time period that we are given, because we take them seriously. But there will always be an issue of the lawyer in between, because the lawyer can claim, no, I've never received the money, when they've actually received the money. So we do take this issue seriously, Chair. If there is anything that we do, we put the claimants first in what we do. Honorable Maduna, I went on explaining this issue. Section 24.5, like Section 18.4, like Section 19C, like Section 19D, are nonsensical. They are. They criminalize common sense. The system itself that says sue me to give you a social benefit is nonsensical. Because if you're a social benefit fund, someone must just walk through. Why doesn't SASSA need the very same lawyers? Lawyers are going to tell you something different because they make money. They are billionaires coming out of this thing. They actually lend our people money. They borrow, they give them the money. People borrow from them as they are busy doing, so that when the money comes, they can just take the whole of it. We get, I mean, there was Sprite Incorporated where a person owes, after that, I think they charged that person 724,000 for a claim. The loss of earnings of that person was 241,000. After that was paid, they were still owing the law firm. And that's a fact. I mean, we can go on, and they're not alone, by the way. We'll be disclosing very soon, Chair, these issues. I don't want to, I think we've dealt with illegal foreigners. Yeah, look, defined benefits is the only thing that must, exclusion first, and then defined benefit. We must exclude the rich out of this scheme. And then, after excluding them, then we can deal with the issue of everyone must get the same. Then we know, but it's poor people getting the same. It's not the same, it's not me also claiming, right? The state tried in 2008, I think the parliament passed the amendments where they removed that 25,000 for public passengers, but you know who public passengers are, right? They were until 2008 the maximum was 25,000. Before then they were paid only 25,000. What the private sector is not going to tell you is that there's a thing called the public passenger liability insurance. They've been collecting those monies at least from 2008, and they've never paid a cent to these public passengers that get injured. And it's a thing that they are hiding. We have taken this to the Financial Service Conduct Authority, and I think it's important that SCOPA must ask how far, because we are told there are 22 of those that are busy getting the money from these people but never have paid anything out. I think that also becomes important. SCM staff and lifestyle audit, we like any other organization that is in the state and procurement, I don't think it's even specific to public entities. Mines are dealing with that. I know a lot of mines that have got a problem with SCM staff. So we do, from time to time, run those kind of things. We have an internal investigation unit, forensic investigation that is inside there. This is where we pick up all these other issues. Ours is not only SCM, by the way. The people that finalize claims are in our area the biggest challenge, because you'll be surprised, lawyers asking you, why did you suspend this guy? Because that's the guy that gave them into the kitty of RAF, who can easily say, well, it's a claim of 5 million and say, I'm giving you an offer of 10. Because we rely on their professional judgment. You may never know what then happens, but we do follow up on the lifestyle of those individuals and all that. Honorable Bulose, you are right. I think the issue is this, and I think if we were recognizing the liability as an insurer, we'll at least be sitting with more than 500 billion actuarial liability that sits in our books, and the state must go and find it. So if we decide today, let's just say we're an insurer, our view is that will be malicious compliance. You come to us, you say you are an insurer, just account as an insurer. We say, oh, let's show them. Let's change our accounting policy, account for it like that, 500 billion, and come to you and say, give us the 500 billion. I don't think that's how, as professionals, we want to deal with this issue. That's why, for us, it's important that the way we are classified is important. The audit outcomes, I think they are clear, they are green, and there's for a reason, and I think you must, if you don't believe us that things are in the way that they are, at least believe the AG. Perceptions. I hear that sometimes we are told perceptions are reality. Well, I don't believe that. Every day we fight battles. People have got the PR. In fact, when we started this lawyers told us that they are going to spend time. They went around even asking for money. They said, we'll keep you in court for as long as you are trying to change this thing. We don't want to leave the scheme. This scheme must be like this. Yeah, that's why they will fight RAPs. They will fight any change you make. We have received, if I'm not mistaken, I mean the department can confirm, we have received more than 5,000, 30,000 comments. You are never going to find claimants there. You're going to find some organization masquerading as claimants, all of them never being injured, but all of them actually in more way than another being lawyers. So you are going to find that. What is the solution? It's simple. Just be a social benefit scheme and don't ask people to prove damages. Once you know they are injured and all that, you don't need to sue someone to receive your social benefit, and that's our view. It's a view I hold. In one way or another, everyone in this room has been somewhere affected by this thing of RAF and knows someone who has been swindled by lawyers. It's not that we scapegoating them. I'm glad that there was maladministration finding around the LPC by the what do they call them? The Ombud, the legal service Ombud has found on some area of, I think, scheme and attorneys, where we are saying charge these people, and they were found that they did not put the real charges against those individuals, and there's something wrong that they did there. And we were going to prove a lot of them, because I can tell you the 102 law firms who have reported to the LPC up to today, nothing has happened. In fact, they were telling us that there's nothing wrong with someone stealing the money, and when we find them with that money, they say, no, they've paid it back, so don't bother following them. So that's the kind of things that we deal with on a daily basis. It's not an easy task, Chair, but that's what we've been doing. I hope that I've answered all the questions, Chair. Thanks.
Yeah, thank you, Mr. Lutola. I think actually you've, unless somebody has got a complaint, I think you went through them one by one, by name. And thank you for that. I appreciate it. Honorable Deputy Minister.
Thank you very much, Honorable Chairperson. And I think that you have received responses, and there are commitments that you have made to follow up on some of the issues. But I think there are just some few matters which I would want to look at and respond to the questions which have been posed to myself. Chair, in the first instance, I want to put it to you categorically, without any fear of contradiction, that we hold the view that REF needs to be reformed and reviewed in order for it to be sustainable and viable, and to fulfill the core mandates in which it was intended for, and for it to respond to the prevailing realities of our times. We are already in the process in the department, and will be expanding our scope of consultations, and I am hopeful that I will arrive at a point of an establishment of a REF advisory panel or forum to assist us look at all these matters in their multifaceted nature, because as other laws change, they've got an impact in terms of how REF performs. Let me make one example. When you bring in the NHI, what's the impact of NHI into REF? It's a consideration that we need to make. Above and beyond, Chair, on the key question of sustainability, we are currently in the process of facilitating the Road to Rail program and the work of the National Logistics Crisis Committee. What is the impact of moving from road to rail? You're going to lose revenue insofar as your fuel levy is concerned. So as we work towards de-risking the roads and decongesting the roads, it's got an impact on the income stream of the road accident fund, and hence I make the concerted comment that we do need to diversify the revenue streams, and that is work that is being looked at. Secondly, Chair, we've got the targets which are necessary for us to pursue, which is reducing the number of fatalities and accidents on our road. We're losing 12,000 lives on our roads. So the safety element of it is an enabler for the sustainability of the REF. If you de-risk the roads, decongest the roads, deal with the accidents, you limit and decrease the scope of responsibility and liability that the REF has. So those are all considerations, Chair, that are on the table, and we are working to look at them. Chair, I think it would, however, be wrong for us to be in Parliament and refer to the Constitution as the so-called Constitution in this body. When we take an oath, we do not say that I'm swearing to the so-called Constitution, because then you alter the direction and course of accountability insofar as the benchmark of the standards. And I think that we've got a responsibility as MPs to guard against that. Secondly, Chair, I think we must disabuse ourselves from Nongawuse kind of style of, commentary, where if we are having robust debates, then we say the head of the CEO is on the block. It's an incorrect assertion. We have to have the difficult conversations in order to arrive at solutions, and he's the CEO. So I don't think that we should now have scaremongering tactics that we are employing here, which seek to deflect the attention from the issues and then come up with other things. I mean, we have had a board meeting, an AGM chairperson, and amongst the issues that were raised, the board has subsequently come back to me with a response yesterday, which I received last night, and I'm applying my mind to the issues that they have raised, all as part and parcel of the difficult conversations that we are having about what is actually happening at REF. Fourthly, Chair, we fully agree the whole notion of foreign claimants, legal or illegal, has to be reviewed, and it must be part and parcel of the visa review agenda which the country is currently seized with. There is something fundamentally irregular in that. There's reference to a Swiss claim. There's also claims from Americans, I think 101 million rands, and there's Belgian doctors claiming 131 million rands. And the dilemma is that some of the actual projections are not done on the basis of rand terms. They are done on the basis of euros and dollars, and then we have to convert, and then it shoots the figures through the roof. So there's certainly a need for us to actually look at that. I certainly hold the view that if you're coming into the country, there have to be terms and conditions to your visa, including but not limited to you having insurance. There's no negotiation about that, and I made this point very clear to the board when we met for our AGM. Chair, the other issue we need to fundamentally deal with is the key question of culpability versus accountability and liability insofar as the whole claims are concerned, in order to deal again with the liabilities which the Road Accident Fund is confronted with. Chair, however, I think here one must be very clear, as I was earlier on. It remains the position of the ministry that after 3 court judgments against the RAF on the accounting standard matter, that continuing on the path of appeals would be reckless and irresponsible, and not in the collective interests of the Road Accident Fund. Nobody is against changes in the accounting standards, but it has to follow the parameters of due process. And in this case, that has not happened. So I think we must not play a finder-finder on that one. The RAF, in our view, we expect it to comply with the court judgments, and we expect it to comply with the findings of the AG. That does not mean parallel to that, a process must not unfold for the purposes of a change of an accounting standard, if so deemed necessary. But what we do not want is an RAF that is living in courts, and I want to reiterate a letter by former Minister Mbalula, actually, on the 4th of October 2022, written to the previous scoper, indicating that that administration had put it to RAF that it is not desirable for them to be in court. That position stands. And we are of the view, Chairperson, that we cannot be selective in what we accept from the AG and say, no, if they say the right things and the nice things, then we agree. And when they don't say the things that we want to hear, then that it's otherwise. Similarly with the courts. You've got individuals whom the court finds in their favor, the courts are great. When the courts don't find in their favor, then we begin casting all sorts of aspersions. There has to be a semblance of principle, which is the yardstick measure of what we do and how we do things. And as far as we are concerned, an audit outcome is the basis or the North Star about how we respond to the challenges. We have got every intention, Chairperson, to give REF the necessary support for it to do the right things and fulfill what it's expected to fulfill. There's no ambiguity about that. But I want to put it to Chair and this committee on the record that we are not in agreement with the direction that is being taken insofar as this matter of the accounting standard is concerned. And that is not prejudiced by anything else other than the fact that the journey traversed so far indicates, even through the legal system, that it is not a viable and sustainable path. why should we continue on it when we should actually be focusing on finding ways and means through consultative processes and engagements? And I say, Chair, what I said in the beginning, any changes required must follow a legislative review. And that is the commitment that we are placing on the table. That is the exercise we are engaged in. I've already asked the DG and the DDG that we begin a process of putting together the technical team to make sure that we bring the necessary knowledge, skills, and expertise required. But, Chair, this court action and any further court action is a red line for the ministry. And we will not accept that it continues. But as Chair, as I'm saying, I received the response of the board chairperson last night, and we will continue with the process. But what I want to conclude by saying, Chairperson, is this. Is that we all have a duty to assist the Road Accident Fund honestly and correctly. And what is not right is to cast aspersions on the process, because we don't assist the Road Accident Fund. And as far as I understand it, Chairperson, you cannot be receiving the same audit outcome on the same issue. And when the AG says that they can't alter an outcome, that's correct. Did the mediation processes break down? They did. But simply on the basis that everybody didn't do what they were supposed to do. So I'm pretty concerned to say that it in future it would be beneficial not to quote letters that are not yours in a meeting, to quote from letters that were not written to you in the question and answer session. I'll leave it at that, Chair. Thank you.
Thank you, Honorable Minister. Not Minister. Thank you, Honorable Deputy Minister. I do not want to get into trouble with the actual Minister herself. I also want to welcome you, Honorable Chair of the Portfolio Committee on Transport. Thank you very much for joining us. We are heading towards a conclusion. I had said that I am going to ask some questions premised on the presentation. I also want to say to the Road Accident Fund that, and I will have some comments for you, Honorable Deputy Minister, at the end when I conclude, for you to take note of. But I am going to now ask my own questions, which are premised on the presentation itself. Various aspects there. They are largely clarity-seeking questions. And so I only dealt with the matter of the accounting standard earlier on. I am now going to proceed with parts of the presentation, if that is okay. Can we go to the slide that has? I'm just going to look here so that I can. Slide number, financial performance, statement of financial performance, the one that starts with revenue from exchange transactions, investment revenue and other income. You see that? 2020, 63 million, 160 million, 223 million, 286 million, 702 million. Can you give me a breakdown of what's contained in those investments? I just want to get a sense of what are the components of that investment revenue and other income? Do you, I just want to know.
It's interest.
What form does it take?
In interest, Chair.
It's interest and on cash sitting in a bank somewhere.
Yeah.
Thank you. Do you have no other investment?
Yeah.
Am I correct to read that? So let's go back to, in fact, not go back, net fuel levies. It would appear to me that what you said earlier was true, in that you have not been granted an inflationary increase on your levies from SARS, so the fuel levy, right? So it's probably at 2012, 13 levels, if that. So I recognize a shortfall, but what it also tells me is that your transfers from the fuel levy have been constant.
At least in the, it's not the 2013, it's the last 3 years, Chair. Yeah, since.
But also, I mean, in substance, they haven't given you much of an increase at all, really, actually.
Yes, nothing for 3 years.
For 3 years, I agree. It's apparent from what I can see. But I also notice, if I look at the row before, that the amount of cash that you have sitting in the bank has also increased, notwithstanding the fact that you have not had an increase in transfers. Would that be correct? Because if it's purely interest, in other words, there's no other investment instrument that you are using, I can assume that this is in a call account. Would it be a call account?
Yes.
Okay, so the money is in a call account. In order to earn an escalating interest, as we see that, the amount of money that is sitting in the call account has to correspondingly increase. Would that be correct?
Yeah, the balance that you keep will correspondingly increase, Chair.
Okay, so Road Accident Fund has, notwithstanding the fact that you're not getting any better support financially from the National Treasury, managed to have an increasing amount of money sitting in the bank such that you've got that amount of interest. How are you doing on your claims? The period you informed the committee is 180 days, is it not? Or is it 120? Which one applies currently?
It's 120 days, Chair, of after the settlement has been reached or the court order.
What percentage of your claims due falls outside of that stipulated period? In other words, which claims are you behind your schedule of what that stipulated period? So how many claims, what percentage of claims or the quantum begins at 181 days and onwards that still have not been settled? Do you have that to hand? If not, you can send to us in writing.
Yeah, I think we might have to send it in writing. We don't have it here, Chair, but it must be quite a small amount of claims.
All right. Now, I would be careful about saying that before you send it to us. So protect yourself by just sending it to us, right? So the amount of claims that are that are older than that much. I would hope so, given how much money is accumulating in your bank account. Certainly would. Because what that tells us, what you are telling us with your answers that you've given, is that you are by and large meeting the deadlines by which you must pay your claims. Is that your statement to the committee in substance?
Yes, in 180 days, yes. Save for, Chair, the ones where most of the time the people did not adhere to the requirements for the payments.
Okay, I'm going to come to that, Mr. Litswalo, actually, but thank you for noting it. So can you please make a submission in writing? So please take a note. We want that information in writing. Do you know the extent of your default judgments that you have against you as a road accident fund?
Yeah, we do, Chair. The ones that are reported to us, yeah, we know.
Okay. Will you please, I mean, if you know off the top of your head, can you give us a number, 2 numbers, if you have? But if you don't, I don't expect you to know this off the top of your head. How many and what the total value thereof is?
I don't have the number, Chair. We can provide that number.
Okay.
Yes, my apologies on that question, if I may, because I think one must assist here in that we are already in the process of engaging with the Department of Justice on key areas of assistance to REF-related matters, whether through the establishment of a special tribunal with the status of a high court or through decentralization mechanisms or the, what do you call it, the independent adjudicator, that's the term that REF has, so that we can be in a position then to deal with the issue around default judgments and court-related matters. So I just thought I should add that aspect, that in light of what you are saying on default judgments, there's an intervention on our part to make sure that we're working with DOJ to sort of begin resolving that particular matter. Thanks.
Thank you very much, Honorable Deputy Minister. Look, I mean, that's certainly a step, both the Road Accident Fund and the medical legal claims process and so on. Something needs to give there. This and it relates to something the Chief Executive said about the amount of money that lawyers make just merely out of the process, of engaging in the process to arrive at an administrative decision at the end is unconscionable. That money should go to beneficiaries, claimants, and so on. I'm in full agreement with that, and I hope that it is expedited as soon as we can. So please finish us with that information. I'd like to know, if the committee members to know the extent of the default judgments. You have, I really hope it's a small number, so that we can get the comfort that some of what we may perceive to be a positive by the amount of money accumulating in the bank does not have a correlative adverse effect on some of your own mandate, which is getting money out. My assumption would be, given how little you get from the fuel levy, and I support you, I agree, you should get more, that I would expect you to be struggling to keep your bank account alive. But at the end of each year, that appears to be accumulating. Can we go to the slide about the vetting of officials? It wasn't quite clear to me, and I want to get some clarity from you, colleagues. Can the committee assume that everybody whose name appears there is, now let me put it this way, everybody whose name appears on this list has been, everybody's name, okay, let me start here. Is that the entirety of your executive committee? Is that everybody?
No, Chair, my name is not there.
Which other roles are not there? The names are not necessary at this point. I just want the roles.
Yeah, well, the roles will be the ones where we have got the vacancies, and mine is not there. Most of them are there.
Please name those roles.
The CEO is not there. The Chief Claims Officer is not there. The Chief Investment Officer is not there. The Chief Corporate Support Officer is not there.
Right. So let me start here then. Is it correct to say people who are acting in role have the full authority to perform the duties that come with that role?
Absolutely, Chair.
Are those people being vetted in any way? The active people in acting roles?
No, Chair, they would be vetted in the ordinary course of them being employed at RAF for that reason, and not as executives.
Would I be wrong, Mr. Litsualo, in assuming that the vetting is meant to manage a risk? It's not to determine whether someone should be employed permanently or not. It's to manage the risk that you have a person who's inappropriate in role. That they're acting or not acting should be immaterial, especially when, because that's going to be my next question. I want to know who's been acting for how long, right? So in other words, as we've seen in these state entities, people can act for a year, 2 years, however long. So is it your assertion that as far as you are concerned, and you board chair, because you've got an oversight role, if somebody is in an acting role in an institution, they don't need to be vetted in a critical position? Would that be, in fact, let me ask the board chair.
Chair, in terms of risk management, it's not right, it's not correct, because you're right by saying you're managing a race. So a person in that role should be vetted. So I do agree with you. But there's other dynamics that happen because people start avoiding, because you still have to ensure that the person accepts in that acting position. But in principle, it's a risk and they should be vetted. So I do agree with you.
Chair, how many people again are in executives, are in acting roles? So the Chief Claims Officer, the Chief Corporate Support Services, Chief Corporate Support Officer, similar role. The Chief Compliance, the Chief Claims Officer, what other role? What is the other? Anyway, there are several roles on the executive committee where people are acting with full authority, no vetting. I don't think that should be acceptable. On average, how long have those people been acting? What is your vacancy rate in, with this, not rate, but the length of time it takes you to fill those roles?
Chair, it would depend. I think one must understand that these positions necessarily came into being only, I think, a year or when was the final? A year and a half ago. Because we were going through a restructuring and some of these positions became new positions.
So has it been 6 months? A year?
Yeah, a year at least.
Okay, people have been acting in role for a year, critical positions, full authority, not vetted, not submitted for vetting, because I'm working by the list that you've given there. Would that be correct?
Yes, that's correct, Chair.
So your name also doesn't appear there. I'm assuming that you've been vetted.
Yes.
Thank you. Okay. So that's an issue. Again, I don't want to hold us up. I am really interested in a written submission. So the committee secretary will ask further questions, but clearly the vetting of officials is an issue. You mentioned a chief investment officer. Do you have a treasurer at the Road Accident Fund?
Yes, Chair.
You also have a chief investment officer?
Yes, a different position here.
Okay. My understanding, and I may be wrong, is that to the extent that there needs to be management of the organization's own resources, own funds, the management of bank accounts and that kind of thing, because I'm assuming, and you said yourself, that the only investment income you have, interest income, is a call account. Is it the role of that person to simply oversee that call account? The chief investment officer, do they only oversee the call account and not the treasurer? They've got to have something they're doing there. What are they investing?
Chair, which is why this position is still sitting in the way that it sits, and someone would just simply act on it. We wouldn't have a thing, because the thinking was that at some point, when we start to be paying in installments, there would be a need to do a proper asset liability matching, which must meet that. And that's not only what people do oversee a call account, so to say. So there is a process of doing what is called cash flow ladders that must tell you at what time you would need what money, and then tranche it accordingly and know how much cash you would need at a particular point in time. And you must also do other things on an actuarial basis. So there's a lot of work that that person is doing. It's not only managing a call account.
Is there legislation right now or similar that authorizes or forces the Road Accident Fund to pay in installments?
Yes, there is.
Are you currently paying anybody in installments?
No.
Okay. Who oversees the call account?
The treasurer together with the CFO.
Okay, so this is going to be the chief investment officer role is going to be an area of ongoing conversations between us. So we don't need to ventilate everything here, but it's going to be an area because people need to have a role that they're doing. And maybe in your submissions, you will satisfy the committee that that person actually has a job to do. But right now, the only investment that's taking place at the Road Accident Fund is a call account. And that call account, I'm assuming, is managed by the treasurer.
Chair, there's a lot of processes that we are undergoing as a transforming organization. It must be understood in that respect. But with respect, Chair, there are roles that we run as I am the CEO, and there are certain decisions that we take. Part of it is to develop is organizational development, which includes developing a structure for an organization. That process continues to be an iterative process where certain aspects and the work keeps on being done as we proceed going forward. For instance, this person who is an investment officer chair is seized with the development of what we call the formulae. This is the development of a formula to make sure that we standardize the benefits across, meaning if me and you were earning the same amount, we don't want it to depend on which lawyer we get. We are working on that. So there's a lot of work that we are doing. We are doing investment policies, and we are doing strategies that are associated with that. So this person does a lot of work. So we'll give you that, Chair. But I think it's also important that we are also given space as executives to exercise our roles as executive. We wouldn't want a situation where the oversight body would then determine how we structure the organization. I think that would be wrong. It must be understood in that space. So whatever we share, we'll share those things, and we might disagree as to what you view as the role of the investment officer and what we view as the chief investment officer. Because for obvious reasons, as different people having different experiences, we may not come to the same conclusion, Chair.
I'd be careful about using the word disagree, Mr. Litsolo. We might convince us. So let's not go there. So that's going to be an area of inquiry. The area of claims. Do you have a chief information officer at the Road Accident Fund?
Chief Information Officer.
CIO, Chief Information Officer. Did I miss? Not here. Do you have a Chief Information Officer?
No, we have got someone who's responsible for transformation, digital transformation, and that person reports to the Chief Strategy and Transformation Officer. That deals with IT, if you want to put it in that sense.
Yes, that's important. I'll tell you why. The quality of the data that you have. So there's several matters that usually come out of audits. The level of security in the system, whether the organization is fortified against cyber attacks and that kind of thing. The management of electronic data is important. The ability to synthesize and analyze to assist your claims processes and so on. So we are going to have a conversation around that. We don't need to ventilate all of those issues. So the chief information officer, there's no chief information officer. The person who performs that role in substance reports to Mr. Patuchedzo Lukwarin. That would be correct.
Yes, the person that deals with, which is the head of digital transformation.
Who's the chief claims officer at the Road Accident Fund at the moment?
I am.
You're acting in that role?
I am assuming that I can't act in that role, Chair, but I do the main work there.
So the chief claims officer role has been done away with officially?
No, Chair. We have been trying to fill this position. I think we have advertised and interviewed more than 3 times. So we are still looking for that person.
Okay, that's also good. And so the vacancies in general, the vetting of the people that are acting in those roles is an issue that we're gonna need to deal with, because members cannot raise SCM issues here and then we also don't talk about the vetting of all of the executives. So it's got to be a comprehensive process, but we will have that conversation in our future engagements, right? So those were the questions from me for now. What I will do, and there's going to be, so I will engage with the minister and the deputy minister. What I want to do, and I wish to assure you, Mr. Litswa, believe me of all people with my background, the last thing I want is for members here to interfere in operational matters. The reason I invite ministers to come by themselves is to stop this conflation and asking ministers operational questions and that sort of thing. So believe me, what I'm about to say now is not going there. Don't have that anxiety. There is a board that oversees what the executives do. This committee will hold the minister and deputy minister for all of these things we're talking about with the legislation and the faults and so on. The person who's going to be in the pen is the deputy minister. He must make things happen for you, together with the minister, to solve some of these things. We're not going to bother you with those issues. The board and management will bother the board with governance and oversight matters, and the executive with executive matters, so that the lines are clear. So that's not where I'm going with these questions. In order for our interactions to be qualitative and not long like today, we are going to need certain information ahead of time. It's part of that process Honorable Blose was talking about, which is an extended induction in education and so on, so that we can get to concise questions when we're dealing with one another. We will provide you with guidance on a comprehensive presentation to make to the committee in future that deals with the matters we've raised, as well as any issues that we correspond through the ministry between ourselves, as information that we prepare in a pack for the members so that we can engage on these matters properly, right? So those are the questions from my perspective. Where I'd like us to get to, Honorable Deputy Minister, Board Chair, and Mr. Litswalo is the Chief Executive. Here's my attitude. I'm here to help all of you. When the policies reflect what the honorable members are saying should accrue to the South African people, you've got a strong ally. We will support you as a committee, and I think the committee members want the same. Matters of board oversight, similarly, we will support the board. I know that in some cases, members sit in one committee, deny an entity budget, and then come and sit here and ask an executive, why didn't you do the thing we didn't give you money for last week? I am going to hold the members accountable to that. I refuse to let them off the hook when they do that. So which is why I recognize that the money that you are getting is not enough. I recognize the funding model is inappropriate, all of these things. So like I said, the facts are the facts. We must stick to the facts but solve the problem. And finally for you, as the executive team at the Road Accident Fund, you have our support in meeting your mandate. But for all of 3 levels of accountability, there's got to be clarity on who does what the appropriate targets are, and how we get to an entity whose finances are healthy, whose governance systems are proper, and there's a link between that and the benefits that the South African people get to. The Honorable Chair of the Transport Portfolio Committee is here, and on policy matters we will not interfere, but him and I will work together to get our respective committees to make sure that we help you where we need to help you. And there's accountability where there needs to be accountability. Like I said, we're not here to get people. We're here to solve the problem. So that's all from me for now. I don't know if the members have any follow-up questions, but we are going to have a follow-on conversation. Can I ask that we are concise, we specify who the question is for, and I will give an opportunity to the board chair, Mr. Litsualo, and the Honorable Deputy Minister to deal with those matters, and then we leave it here. Thank you. Concise, please. Otherwise, you're going to make me a liar when I said we're going to leave on time. Thank you. Honorable Skosan.
Thank you, Chair. I'm going to respond, obviously, and politically so as well, because the Deputy Minister chose to respond politically. And on that one, I'm not going to mince my word on that. To say one cannot cast aspersions and say things which are not fair factually. I'm not going to come here and talk about things which are not factually. That should be very clear. I'm not dreaming at all. What I said here, I'm going to emphasize on that. When I said that the issue of the Constitution, and when the CEO was briefing us that unfortunately as members of Parliament, we have to resolve these matters in Parliament. The Constitution is not serving our people, it's a fact. And those who believe that this Constitution serves the poor people should say so, it's fine. But they should not be insulting us. Some of us who believe that the Constitution is not serving our people, in particular the poor. And I know, because some of us, we read as well. I'm not sure, CEO, whether are you still safe? Because the last time I was at REF, because some of us do oversight as well, the CEO's life was threatened with death, like some of us. And we should not take things, as if courts or the AGs are alpha and omega. And this country, the Constitution allow any institution to go to the highest court in the land. We cannot say that, no, you have already exhausted the courts, this thing of court. If the institution feels that they have to take the matter to the highest court in the land, so be it. Every institution, every department has done that before. Why this department, why this entity is being subjected to be saying, no, there's 3 findings, therefore, no, you should cut your losses. You can go to the highest court if need be. That's why we have a lower court and the highest court in the land. So it cannot be right to intimidate the CEO to say, you cannot go to the high court, to the constitutional court, or to go to the Supreme Court of Appeal. It's completely wrong. And if we as members, we are not protecting the institution, then we should not be here. Then the executive should do as they please and get involved in administrative matters. It cannot be right. And we should not intimidate anybody.
Will you wrap up, Honorable Skosan?
I'll wrap up. I'm saying here, the CEO has explained to us, Section 19, he quoted Section 19, I remember very, very, very well. To say if we want lawyers to milk this institution, the executive should say so. The CEO must pack his bag and go home. If he's not going to protect the poor of this country, because they are in a cold phase, they are dealing with these matters daily. And I'm saying there's not even a court or an AG, which is alpha and omega. Once they say something, then you know what? We must fold our arms and not question them. If in this court, we question courts as well.
You're repeating the point.
Yeah,
and
I'm saying I want to
make short comments, please.
Yeah,
Otherwise,
I understand that,
lose
Chair.
the meeting.
Chair, I understand that. I know that you had time. You know, I needed more time, but it's fine. Maybe next time I'll get more time. But really, I'm irritated when in a meeting, then somebody say we cast aspersion, you don't have facts. I'm not going to allow that. People's lives are at stake here. Some of us were being intimidated as well.
Thank you.
Thank you.
Honorable Kubega.
Thank you, Chair. Chair, a few comments and some questions for me. specifically to, like you said, we must direct them to specific people. I would like to direct this first question and the second question to the CEO, Mr. Letswalo. Earlier on, when he was giving us a background of what happened at RAF and how they arrived where they are now as RAF, he told us that in 1946, yes, it was 1946, basically RAF was opened and it was based on common law principles. The question there is, in 1946, were black people allowed to claim from RAF? And then again in 1986, RAF collapsed and for 5 months, and then it was revived again. And then after it was revived, were black people then allowed to claim from RAF? And then another question is, up until 2008, public passengers were not allowed to claim. And I know when they say public passengers, that's mostly black people that they're talking about, black people who would be mostly in taxis and so on. How much they were allowed to claim? Only up to 25,000 rands back then, up until 2008. How much are they allowed to claim now? Is the next question. And the next one is, how do we help RAF criminalize lawyers who swindle money from our people? Because from what the CEO was saying, again, Section 19C, which basically says that you must have a lawyer, and which is what lawyers are now using to exploit our people. How do we help the lawyers that do actually criminalize our people? How do we help RAF criminalize and even go as far as prosecuting people? I think that one we can actually discuss and liaise and see how we would get to that. And I think this one now is for the minister. I think it's more a comment on considerations when moving from road to rail. I think, Minister, we really need to look at the loss of finance that would occur there. I agree with you on that one. And then I would like to disagree with Minister here, or Deputy Minister here. And I do believe, Mr. Letswalo, stay in court, stay the course. RAF needs to be in court for as long as yourself as the CEO and the board deem the outcomes of the lesser courts to not be favorable or conducive to the entity. Stay the course. I do agree. I would like to really agree with the Deputy Minister when he says you have gotten one or two lesser judgments from the lesser courts, and if you feel that that is not enough, go the whole course, stay the course. That's what you are there for as a CEO, and if your board supports you, stay the course, please. That we realize and we know, or some of us realize and some of us know, that you're doing this for our people. So stay the course, fight the good fight. And then on that same one, I think, like my colleague here said, other entities, they go to court when the courts that they've approached do not agree with them. Like here, for instance, there's another one that was very contentious not too long ago. In Parliament. Parliament made a decision. Some people took Parliament to court. Why should RAF be different? I don't get it. So please, CEO, fight the good fight. Take all of these judgments and or legal issues to the highest courts if you have to. Thank you, Chair.
Thank you. Honorable Esak, do you have anything to say?
Chairperson, I promise you I will be concise. Okay.
Please.
I have no plans to get emotionally
Thank you.
caught up here.
Please proceed.
Deputy Minister, with due respect to you, we've been sitting here like for what? 4 hours, 5 hours nearly going. And I just want to say this with due respect to you, sir, and perhaps you can point this out to the rest of your colleagues. And, you know, I read up somewhere. that over and above everything we've listened to today, it says here, the Public Finance Management Act remains the primary legislation, sir, that classifies and prescribes the accounting framework to be applied by the Road Accident Fund as a Schedule 3A public entity, unquote. So in all the discussions we've had, with due respect, ladies and gentlemen, nobody has ever mentioned the PFMA. How come? In spite of everything that's been pointed out, that is what I would like to understand, because I think as members of the committee and as institutions of parliament, first and foremost, we prescribed by the PFMA. I think you'd know that too, sir. So that's the one point I've made, sir. And yeah, you know, looking at all these court cases and the 10.7 million rand that's been expended thus far, you've just had a colleague of mine saying, stay the course, keep on going to court. Have you considered the way forward? Should your last court exercise now fail? After having expended so much of taxpayers' monies and still not being able to bring this to a point or some finality. Because at the end of the day, you heard colleagues of mine say, yes, we are here to serve South Africans as a whole. We need to start applying our minds. I said that in the beginning, Chair, and I'm saying it again with due respect, Deputy Minister, and I trust you will carry this message through to the board. Thank you, Chair.
Thank you, Honorable Esak. Honorable Skosana, do you have any final comments?
Yeah, just one comment, Honorable Chair. From what the Deputy Minister has said, I think he will correct me if I've heard him wrong. I think from what the Deputy Minister said, I understood him to be saying that RAF can proceed with their court processes. However, that should not hamstring the entity in terms of being accountable and doing their work. So they should not be stuck with the processes of court that they then take off their eyes from the ball. They should focus on their work, being accountable, serve our people, while at the same time they are pursuing that. Not unless maybe I did not understand him well.
So I think what he said is exactly the same. What the Honorable Deputy Minister said is exactly the same what Honorable Maduna said. In substance, what I understood them to be saying is that if the Road Accident Fund is unhappy with the applicable standard, they can litigate. However, until the courts decide otherwise, comply with what you need to comply with now. It's not to say don't do it, it's to say until the courts say otherwise, follow the rules as they are.
Chair,
Mr.
Chair,
no, hang on.
Chair, the minister will answer for, the deputy minister will answer for himself.
Okay,
please, guys.
that's fine. Honorable
Please.
Skosana, that's what I understood the member and the minister to be saying.
Yeah, Chair. Yeah, Honorable Chair. No, I was not answering for the minister, but I wanted us to find that balance, which I thought, in my view, it is important. And I think I understood him in the same manner that you understood him, Chair. And I think that's a correct view, and I'm agreeing with the minister on that. That for as long as the RAF, the board, and the CEO feels that they should pursue the matter, I agree with that. But while you are doing so, because for now there's a pronouncement of a court which we should adhere to, while you are still pursuing the matter further, but we should be able to adhere to what the court for now has said, while we are still pursuing it with other court processes. So I'm agreeing with the Deputy Minister on that. So I wanted us to put that into correct context. Thank you very much, Chair.
All right. Honorable Atkinson.
Thank you very much, Chair. And I just want to make a couple of comments because I think some inaccuracies have been made today, well, have been said today, which kind of put a particular line. And the one is that issue about the 500 million rand claim from the Swiss. That apparently was 16 years ago. And apparently the legislation has been changed. There's actually a cap in place now, so that cannot happen again. I agree with you, Minister, the fact that our visa regulations need to be changed, and that when people come to the country, they need to be able to have their own insurance, and that probably should be excluded from the future. But I think there's this bogeyman that's been put in the air there about foreigners making claims, and the 500 million. As I said, that was 16 years ago, and the law has been changed since then. And then the second point as well is this issue about lawyers. Okay, I'm not a lawyer myself. When a person comes to make a claim at RAF, I believe it's quite a complicated process. So if we talk about excluding poor people, we're excluding them because of the complication of the process, okay? So quite often they can't get something through unless they've actually got a lawyer involved. And I'm sure all of us have some knowledge of law and we understand the basis of lawyers working off contingency, okay? So where a lawyer will not charge you upfront, but will take a percentage of your claim if it's successful, okay? So the lawyer himself is putting time and effort and money, and he might actually get zero out of it if the claim doesn't go through. But at the end, he benefits and benefits quite generously if the thing does go through. So as a poor person, is it better to take 75% of a very large amount of money or 100% of nothing? I think that's what we all need to think about as well. So yes, I do understand that there's a little of a populist view, you know, that lawyers are rich and they're taking money out of the fund and everything. But at the end of the day, it might actually be the only route for a lot of poor people to go on a contingency basis with lawyers, and to be able to get the advantage of a settlement from the fund in that way. And then the third point I want to make is just this issue that the CEO mentioned, the fact about looking after the kitty. You know, that obviously there's a limited amount of money in there. You know, it's money that comes from the levy. And at the end of the day, I think the really important thing here is that's not your sole responsibility. It's actually the responsibility of the minister and the government as to decide what to do. So if this fund has been run in the proper way and the correct amount of liabilities are being accepted and people can get a clear view of what that is, it's actually up to the government and the Department of Transport to decide how this thing will be funded, okay? Whether the road accident levy is enough, whether it needs to be increased, or whether money needs to be found from other sources of government. So I think your responsibility is to pay the claims as are mandated in the law and by statute. And at the end of the day, it's the minister and the government that need to decide how to come up with that money to be able to do that. Thank you.
Thank you. Honorable Matlala.
Thank you, Chair. I think mine would be just comments at this point. I had said everything I wanted to say. But CEO, I want to just say I agree with you on a lot of things. One, exclude the rich from the scheme. Cut the lawyers out. You see, what we stand to represent here are the poor people of this country. And without having to rhetoric and mention semantics and try to sound smart, the reality of the matter is that the people should be benefiting directly from the fund. The issue of the legalities and the you know, the branding is what is in our minds. You know, not in the hearts of the people on the ground and what they want. The inability of the government of national unity to mitigate the issue between their departments is not part of my problems. But I agree with you, and I want to check with you where that bill is, because you said there was a bill that was proposed with amendments that seeks to resolve some of these problems. And that is a bill that I would obviously lobby my party that will resuscitate. Thank you.
Thank you. Honorable Maduna. You've landed.
I'm well covered, Chair, by honorable members.
Honorable Blose, you've also landed.
No, Church, I have, but just a comment. I can't resist. No, I think for the record, Chair, we ought to register that the biggest beneficiary of RAF is a white person from Switzerland who mixed this entity of 500 million. And the Deputy Minister, when he's responding, he must tell us about this reform that has been changed and the cap. Because seated here, I'm not aware of that. So if there was a legislative change, the deputy minister must advise us on that, and so that because we must not be misled. In fact, the deputy minister even gave us other white people who are taking 102 million and all of that, and our people are really not benefiting from this thing. So that's why there are so many emotions. CEO pay. Yeah, because you can see who this money is going to. Our people are not benefiting in this thing. And then we are going to ventilate it in our strat committee. And then we'll, fortunately for me personally, I also sit in transport. So the beneficiaries of this scheme are in trouble. We are here to make those changes. Thank you.
I'm going to get you out of that committee so that you're always here. I am fighting with your political parties, by the way. I am fighting this business of people missing SCOPA meetings. I don't like it. I want to have my people here all the time. Please. So, please, Honorable Kupeka, please be short, please.
Thank you, Chair. Chair, can UCO answer this? He said something. Foreigners can be here illegally, but constitutionally. Please, I need clarity on that one. I don't understand that.
Thank you. So that we do not operate in the realm of statements. In that submissions, one of the things that the Secretariat, Mr. Litswalo, and you, Board Chair, will ask you, give us a breakdown of the beneficiaries. Do you keep that information by race? Do you do that? Because Parliament must always operate on the basis of facts. Do you note down the racial composition of the claimants who get paid out?
We don't necessarily do that, but it's possible to do it, Chair. But we'll give it a bite at it. But let's agree that we know who earns the most in this country.
No, Mr. Lutolo, I'm asking you a different question.
No, I'm just saying, Chair, the reality is this. I mean, I've been asked a question about 1946 and all that. All I'm saying is that where we sit, most of the people that come to us come through lawyers, so it's not very easy to determine whether these people are black or white.
No. So I'm saying, I'm going to give you the Board Chair and the Deputy Minister to deal with all of the comments of the members. Me, as the Chair, I'm asking you a different question. And that question is, do you have information you can furnish the committee with that provides a racial breakdown of the beneficiaries? It's a simple question.
Not at this point, Chair.
Thank you. That's all I was asking. No, Honorable Skosana, please, I've given you a chance.
Yeah, but Chair, I complained the last time you are doing the same thing. You gave Mr. Kupeka a second bite. I just want to say something, and you are preventing me again.
So Honorable Skosan.
No, it's fine.
So, honorable members, this is what I'm gonna do as a rule. No second bites from now on, not ever. Thank you. Okay, that's it. Because I try and be.
With due respect, that's not fair. I mean, Mr. Skosan.
No, I really try. It's a mistake. It's a mistake that I admit. No second bites. You ask your questions when you get your initial chance. So this business of one last thing, Chair, is over.
Mr. Skosan, can move to the transport.
Can I give, please? Can I give?
I was not answered, but I'm saying I was not answered.
No, so which question was not? Which question was not?
The question which you ask yourself now.
No.
Listen to me.
No,
Chair.
they're going to answer it.
Chair, listen to me. I ask about the people who are paid, the lawyers who are paid the 10+ million rand, whether racially so, as you ask. I said we need those names. And I'm asking once again, because we've got an issue here. We should not beat about the bush and try to protect what we know exactly what is happening. So my follow-up question was that. And I think when the CEO was responding to all our questions, and I said, you know what, he explained to everyone, he answered everyone. But this question which I asked, unless you know, I don't know.
No, Honorable Son, I don't want to have an argument. When Mr. Litswalo finished, I did this. I said, you've answered everyone. I looked at the members. Yes. And I said, and you name-checked each one, and I complimented him for it. You did not say anything at that point. So,
I could not say anything because you were talking, Chair. That's
Okay.
why I'm raising it now.
okay, thank you, Honorable Skosana. Can I then, I'll give you, Mr. Litsualo, the opportunity to make concise, give concise answers to the members. And then I will do the board chair closing and then the Honorable Deputy Minister closing, and that's it.
No, thanks, Chair. We were told that any person, as defined in the RAF Act, includes illegal immigrants. And that's why if the RAF Act says any person injured on the road, it includes illegal immigrants. And our fight was about the Immigration Act saying we can't aid and abet an illegal foreigner. And the court found against us. And that's why we have appealed that. And that's why we are saying, the judge was saying, you are here illegally constitutional. So that's the context. Now, Chair, one would not want to venture into politics, and because we are just professionals as we stand here. The black people were allowed to claim absolutely in 1946. But then you understand the point at which the state steps into the shoes of the wrongdoer. This was about the wrongdoer. It was not about the person who got injured. So the state saw people being sued and then decided to step into the shoes of the wrongdoer. And that's why you now need to prove that this person did wrong. So that's how you must understand it. They were stepping in the shoes of the wrongdoer, of the drivers that were hitting people with their cars at the time. So that's the reality. Now, 25,000, yeah, it was until 2008, and now they can claim anything. But as I say, you would see in the numbers, the people that earn the most are the ones that benefit the most from the scheme, because it depends on your loss of earnings. So you must have earnings, there must be, and we know who earns more. It's people like me that will benefit more from the scheme. Politicians as well. Well, I don't know of any politicians, so I can't say that, Chair. How much are they allowed to claim now? I've answered that. How do we help the RAF? Just change the act. Change the law, make it clear. Remove lawyers. Remove anyone who can actually do this thing themselves. They can insure themselves. Then put caps as well of how much you can do that. And of course, I mean, is there a cap? Yes, there is a cap. But this cap was 160,000, Chair, at some point. But the parliament had said that 160,000, thinking 160,000 of the income is 160,000 of the loss. And that's why the rich are still in, because it's the loss, it's not the income. So that must be understood. And as well, it's not an urban legend, Chair. We sit here with 3 Belgians that are claiming more than 150 million from us. It's a fact. The highest beneficiary in RAF is a Swiss national. That's a fact. We can't change that. The 106 million or so of is an American. So that's a fact. Now, how much are we spending? We're spending about, before we started saying no illegal immigrants would come into the space and claim from us, how much were we paying out? 3 billion a year. Yeah, so don't just look at this only one. So all of them combined, 3 billion a year, Chair. So are we doing this legally? Indeed, Mr. Atkinson, we are. There's nothing that the RAF has ever done that is not in terms of the law. We code the law. People that differ with us never code the law. We are telling you 19C says, we are saying to you, there's provisions in the Immigration Act that says we cannot do this. And that's why we are not paying people. You go to medical scheme, anything that the RAF does is by law. And we also get, if we are not sure, we also get other people, senior counsels who will say you are on the right track. So we don't do anything that is rogue and that is not in terms of the law. And I think that also addresses the issue of the PFMA. It does, and I think GRAP 3 comes from the PFMA itself. ASB is a creation of the PFMA, and probably maybe we didn't just mention it directly, but there are provisions of the PFMA. I think it's from section 85 of the PFMA. You would see that it talks about generally recognized accounting principles. So, and practice, that is ASB. We are a 3A schedule. We follow everything in terms of the PFMA. But I think it will be remiss of us or not to also mention the fact that everything is on the balance. So if you go and you say you cost the organization 10.7 billion, we say the outcome of it will save us at least 315 billion. And we say to you, over the past 4 years, we have saved this organization 24 billion. It must be balanced. No one can ever go to court for free, Chair. That's a fact. Now, Chair, we are focused. The thinking that the issue around the AG preoccupies our minds to a point where we can't focus on what needs to be focused on can't be correct, which is why we can get a 91.3% performance, we can get an 84.6% performance because we are focused. Every time we have got these targets, we focus on those targets. We are not focused on, we are not derailed by the thinking that your classification is wrong. No, we continue to do the work. As it would be in our annual report, you'll see that there's a lot of work we are doing. As I said, one of the things that we found was that it was difficult for us to have a direct relationship with claimants. We then opened a call center, hired 300 people that are waiting for calls every day. We've got 288,000. That's why we're focused on the issue of our people. Now, pay what is allowed in law. That's exactly what we are doing. The lawyers charge you up front. Indeed, they do charge you up front, but you must afford that. The thinking that I've mentioned this, I've said we have found out that attorneys are lending people money at ridiculous rates. Attorneys are taking advantage of the lack of knowledge of our people. And that's a fact. You can go to LPC, they will tell you what we have given to them. As I say, 102 law firms have done that. So the fact of the lawyers enriching themselves in this scheme, and that's why they make it so complex. And that's why we are saying use legislation to simplify it. That's what we are saying. The amendment bill, where is it? It's at the point where last year there were comments, as we say, about, 30,000 comments that we have received, that the department has received, and it's in that space. And that's it, Chair. I hope that, Chair, the issue around the lawyers, we can give the indication of who those lawyers, those attorneys are on both sides of the divide. Was it Malaji Incorporated on this one? I think it is Malaji Incorporated, and then I think the senior counsel is Jabu Motepe, and I don't know, and his team. So those are the lawyers that this 10.7 go there. But there must be a context, Chair. If we then win in the SCA, all that money will be paid by the AG as well. So it must not be seen as if it's a one-way train that goes the other direction. Thanks, Chair.
Thank you very much. So one of the questions we'll send you for written submission is around those matters, the legal matters. So, for instance, you spoke about sort of what you saved in legal expenses, that terrain. So we'll ask you a few questions around that, so that the committee members have got sort of the detail. Thank you very much, Mr. Litwal. Everybody has been answered. So. Can I do this? Board Chair, final comments, if any, and then Honorable Deputy Minister.
Thank you, Chair, for all the guidance and the discussions. I'd like to say that with your support, this board is committed to continue running this organization in compliance with the relevant legislations in the best interest of the fund and its beneficiaries. And to sustain this, we really need your support in finalizing the REF amendment bill, because all the sustainability solutions that we recommended in terms of our turnaround strategy are in that bill. And also we would like the committee to assist us in encouraging the ASB to finalize that relevant standard. The exposure draft has already gone through public comments. And then in closing, we will submit the relevant information that you've requested us to. And then we thank you with your support in terms of, supporting us in achieving and fulfilling our mandate going forward without fear or favor. Thank you very much.
Thank you, Board Chair. Honorable Deputy Minister.
Thanks, Chair. I think the CEO and the Chair will benefit from a clarity of the timeline of when you want the submissions so that they can be able to comply with the issues that you have raised, if you can do that. Noting, Chair, that REF, when you give days, it's working days. So just make sure, Chair, that you give them that so that they can submit. What we don't want is to be an entity that is not in compliance with the directives of the committee. Chair, here's the issue, Chairperson. You see, when I arrived in this parliament, I was 24. The one thing that will never succeed in this lifetime or the next is the assumption somewhere that you can intimidate me. So that is clearly clarified. We will come here and engage the issues. One can raise the argument, but don't raise your voice. The second point, Chairperson, is fundamentally this. We remain concerned that an audit outcome has got an effect and an impact on the futuristic outlook of an entity. Seated here, there's an adverse audit outcome for the REF on the basis of the accounting standard. We have to resolve it. And the due processes have to be followed to do that. Until such time, what has been found to be irregular is what we must correct. Comply with the realities as they are now, and when the time comes for change, then do that. That is very clear on our part. Thirdly, Chairperson, it is common cause that constitutions are living documents. That's why there's a provision for amendment. And it is the responsibility of members. You see, the one thing that happened here, we went to Concord and warned members of parliament the right to bring private members' bills, because previously it was a prerogative or a preserve of the executive. And the late Mariam Rosini went to court with our support and came back with that. I want to encourage members that let go beyond the rhetoric and bring to the floor of the House legislative changes and reforms, just like we will be doing, to assist REF achieve what it needs to achieve to stay on course for sustainability. There is no ambiguity that things have to change at the REF, Chairperson. If there's thinking elsewhere that the status quo is favorable in our outlook, it's a misplaced one and it's misguided. But we have to do things within the parameters of process. Fourthly, Chairperson, the REF is not a money-making scheme. Whether for claimants or for the lawyers. And Chair, we must not run the risk here of not asking the committee to engage the professional bodies of the lawyers on the conduct of the lawyers. And what consequence management, because the ref has got a list of lawyers, if I'm not mistaken, of lawyers whom are problematic. What have those professional bodies done as part of consequence management? Because ultimately, Chairperson, the issue is this. I want to make one final example, and I shared it with the AGM. My brother was assaulted by people trying to hijack him and beat him to a pulp. When I found him where he was, I didn't call an ambulance. I rushed him straight to the hospital. After having completed the work of his admission at the hospital reception, a lawyer outside said to me, "You should have said it was an accident." Now, I raise this to say that the professional conduct of lawyers must be within our purview for the purposes of consequence management and ensure that as we reform the ref, whatever role that lawyers will play, we have to redefine that as well, because there have to be checks and balances in the system in any case. Now, Chair, there is clarity on the policy direction, and I'm glad that there's recognition that we are the GNU. The medium-term development plan, 2024-2029, places a particular focus on the road accident fund to make it fit for purpose as part of the pillars of ensuring a socio-economic equality for our people. And there is a submission that has already gone to the DPME, which details the roadmap projections of what the road accident fund seeks to achieve. So, in other words, is that the reforms of the road accident fund, one, they have to cater for the entire ecosystem of a road accident and the consequences thereof. And secondly, it's to ensure that the previously disadvantaged, who find themselves presently disadvantaged, are given a fair chance in the access of the claims. We've not gotten that mandate from somewhere else. We've given it to ourselves. It's part of the reforms we're putting on the table. But we must not disadvantage the poor when we are putting a pro-poor agenda on the table by being reckless and irresponsible about lapses for checks and balance. We must ensure that they are able to access the services of the state to their fullest potential within a framework that does not disadvantage them. And if it's a legal process, then it must be so. Why would we be seated here trying to put in place a special tribunal? It's to deal with the liability, the default judgments, which are a hindrance for the poor. So it's a mechanism. So we're not prophesying about a pro-poor agenda or a pro-black agenda. We are actively implementing it. And the reforms that we are bringing here are so precisely for that purpose. So, Chairperson, I want to thank you very much for the engagements, and I want to thank the Chairperson of the board and the Deputy Chairperson for their engagements, and the CEO and the executives. Finally, Chair, Madam Chair, if there are threats to the life of the CEO, we've got a responsibility to ensure his safety, so that we do not make it a slogan here, because it's a serious matter which has got ramifications for himself and his family, and is less a politicking matter. It's a personal matter for his safety. And I don't think seated here we can sit now and detail the security plan for the CEO. And if there has not been a positive response from the law enforcement agencies, ours is to make sure that we facilitate that it's there. So we are, and the chair is indicating that the measures are in place. If they're not sufficient, then we must beef them up. But what we must not do, Chairperson, finally, members must also be disabused of one outlook. Our expectation is for RF to do the right thing. And it has our support in doing so. But it does not mean we won't have the difficult conversations. And it's not personal. And I raise this in this context, Chair. Anybody sitting out there thinking I'm sitting here with an agenda of the 6th Parliament, they need their head read. because I'm of a sober mind of the delineation of responsibilities, time and circumstance. I am no longer the chairperson of this committee. And when I'm here with an entity which is within my purview, and we have got a professional relationship on the matters. There's nothing personal. Anybody who seeks to make it personal, they are a danger and a risk to governance. Thank you.
I'm glad, Deputy Minister, you no longer think you're the chair of Scopa, for my own sake. So I'm glad you've addressed the issue of the safety, because it's one of the issues I was going to talk about. As you've noticed, I'm going to keep asking for information, because the one thing Scopa is not supposed to be is where we make statements without evidence. So I am going to be annoying in this respect. I'm going to keep asking for information in respect of assertions made, so that the committee members always operate from the basis of fact. We will fail our constitutional responsibility if we do not do so. So, Honorable Deputy Minister, thank you very much. Honorable Board Chair, thank you very much. Board Chair, Deputy Chair, Chief Executive of the Road Accident Fund, and your team, thank you very much. Here's what's going to happen. There are going to be 2 tracks of correspondence from the committee secretariat to the ministry and therefore to the Road Accident Fund. There are follow-up questions that are going to arise from our deliberations here, which will go into a pack that we'll provide to the members, so to inform future deliberations. We are also going to discuss with one another, and it may be necessary to have some conversations with the Deputy Minister or the Minister and maybe the Chair, to develop that accountability template we're going to use between us. So it will not be an arbitrary thing. The information that's provided to the committee needs to be useful to the committee, and it needs to be possible to get that information. So there's just going to be some correspondence about making sure we get to, and the committee members will then, become satisfied that we can do so. I want to say just 2 things. The first is that the people who are primarily accountable to Parliament, Honorable Deputy Minister, is the Minister, and by delegation yourself. Our Constitution demands that we hold you accountable for the adverse findings of the Auditor-General. It falls on the Ministry to make sure that that is no longer the case. We cannot have a situation where it is acceptable sometimes that there's an adverse finding and the ministers don't get to account for it. And fortunately, the minister will be with us next week, and will canvass some of these matters with her. But ultimately, you are accountable for the adverse findings. That's the first thing. The second thing I want to make clear to everyone, in our law, and until our law decides otherwise, we are allowed to challenge the constitutionality of anything, administrative action, legislation, and so on. Until the courts determine otherwise, that law remains in force and effect. It's not for debate. It is important for the public to know that's how our law works. There are currently numerous challenges in the Constitutional Court as we speak on many issues. Those institutions do not proceed to do what they like because there's now a court challenge. It doesn't work like that. It's a matter of principle and fact. It works that way. So, Deputy Minister, it is important that the matter ongoing is resolved between the Road Accident Fund, the ministry. It's unseemly to have a minister being a respondent of a matter in their own department. I haven't seen it before, but that's what we have here. We need to see that the government is functioning. And when there are intergovernmental or similar issues that are at play, the government is capable of resolving those issues. And that is your responsibility as a second point. And finally, I think that we must ultimately be informed by the desire to see measurable outcomes on the South African people only. And that's how this committee, we should apply ourselves to our work. Where we need to support institutions, we will. Where we need accountability, there needs to be accountability. Thank you. We adjourn.